Milord, I appear in this application
I appear
on behalf of
not in the list. This is
I'll-
number 6 for correction.
yes,
But I'm
Milord,
from the list. G6 is appearing in the list for correction.
but
It
other
has not been served on me.
and the other applications are not being.
G6 order was passed.
No order.
No order was passed. Milord, I tell you, losses. Milord, I just.
Malad, this is our application. Let us make our submissions, Malad. This is our application.
Appointed a special
No,
officer.
today is the date for appearing of which matter?
Milord, I
This
find
new
Milord,
matter.
I find Milord that from the application that the application being GA6 has appeared. This is number one. Number two, I think the grievances of my learned friends are that there are in total there are Milord 5 applications.
Right.
Now, Milord, your lordship's Milord, it appears, Milord, from the records of the case that on an earlier occasion, your lordship was pleased to appoint a special officer, Milord, to inspect about the functioning of the particular work of estate.
Yes.
Now, Milord, I very respectfully submit to my lords that the report of the special officer, or if anything has been made,
When it is due to appear,
Milord, 24th.
24th, that matter which I have passed an order is due to appear.
Yes, yes,
Okay.
yes,
So,
yes.
and this GA6 is due to appear when?
Milord,
Your
GH,
application.
this is a new application. Milord,
I've been taken by surprise. How is it appearing? I do not know also.
I just,
Just a minute. Let this record an order.
Milord, I only submit
this-
one thing.
GA6. Let this matter appear on 24/9/2025.
Milord, only one thing. I would
Yes.
be also indicating one thing more.
Yes.
No, no, এক second,
No,
Dharan.
no, let it appear
Yes, yes.
on the same date.
But Milord, all the applications may appear in my lord's list, so that your lordship, I can apprise to my lords about the fact, because I
Other
find
applications, okay, they are already, they were directed to appear on 24/9 probably.
Yes, all
all
the
the
applications, because it cannot be hard in a piecemeal.
No, all the
There I join an issue. I say, my lord, that I will be severely prejudiced. And
issue on 24th, my lord. Your
and
lordship,
my lord, the act, it says, and there is an act as well as there is a scheme.
there is a time for
Insofar
making
as a
submission. This is not the right
So
time. Your lordship is
24/9, let this matter appear on
Just,
24/9. Okay.
Yes.
I'm
So if they are the other matters definitely are directed to appear on 24/9. Okay.
very well.
So let this matter appear on 24/9/2025.
I have understood the order. I'm grateful.
This is GA6.
Yes.
Whose application? Your application.
তুই করেছিস? Yes, my lord,
Okay. Acha, in the meantime, this application be served upon
Yes.
opposite parties.
This has come by back door.
Malad, these kind of submissions, my lord,
Yes,
from a senior
obviously.
friend, backdoor, my lord, it is appearing
I'll
before
make
your
this
lordship.
submission.
My lord, with leave of my learned senior
My
friend,
lord,
I mention this matter.
I will not be making any submission so far
If you
as.
have mentioned this matter, it will appear on the date.
Yes,
fixed.
but these kind of comments, who says that affidavit?
No,
was
you
exchanged?
mentioned, was it upon notice to all the parties?
No,
My lord,
he did
I
not do that.
mentioned it because of the urgency that is
Okay.
between the
What
court and the, my lord, advocate. I would have not prayed for anything.
Now serve the copy of the application.
What kind of comment?
Yes.
He comes and says that
Yes.
affidavit was exchanged,
Yes.
he didn't serve a copy upon me.
So now serve the copy of the
Yes.
application.
My lord, only one indulgence may I pray.
We have a-
My lord, the report of the special officer, if prepared, I do not know whether it has been prepared or not. It may be submitted in a seal cover.
On the next day, I shall pass the. Definitely, all
Yes.
reports are submitted in the seal cover. That is the procedure.
Now, why I say this?
No, this is the procedure.
Yes, why I say, because I find Miller from এক second দাঁড়াও না বাবা, আমাকে একটু বলতে।
I'm sorry.
Miller, I extra agony will not help the case. I say, Miller, only one thing, because after perusing the matter, because this is the first appearance, Miller, I've never appeared in this matter. Now I find, Miller, that the issues involved that has not been also decided by the court, or these issues have been raised. Only, Miller, an impression was given that the Mutwalis are not working. Therefore, Miller, let us calm.
Yes.
Let us calm and let us, Miller, voice our grievance.
Yes.
Thereafter, your lordships may decide.
So come on 24.
Yes, and the scheme your lordship may take into consideration and the act.
Okay.
Consider not.
এখন ওসব কিছুই হবে না।
Position এ থাকে একটু বলে দিন।
Let it retain its
Yes.
let it retain its position.
No, no, it will appear in the usual course. It will appear. The other application will appear for the report. This way, a matter and other matters will also appear.
ঠিক আছে হয়ে যাবে হয়ে যাবে।
কিন্তু ইয়েতে আসছে না
না।
তো, শুক্রবার আসছে
না।
না তো।
নেক্সট বুধবার 24 তারিখ থেকে।
বের
Wait.
করো।
Item number 2. Okay, not today.
Number 3.
So this is an uncontested probate application mentioned at my instance, my lord.
Let us see.
My lord,
What is the present stage? So it is to appear as non-contentious.
my lord, on
Was
the
any
last
caveat filed?
my lord.
Was any caveat filed?
No, my lord, no caveat was filed. There is a consent affidavit of the only legal heir, which is the son. My lord had passed an order on 2nd September.
Let me see.
My
the
lord,
order.
that this I had mentioned for my lord, there is a small correction or modification required in that order, my lord.
Yes.
My lord had directed paper publication, my lord, in one English newspaper and one Bengali newspaper widely circulated in the locality where the testator last resided. However, my lord, from the cost title, it appears that the testator last resided at the time in Puri, Orissa. So, my lord, either my lord may change
One English newspaper
and-
and one local newspaper.
yes, my lord,
So
either
testator is a no. This testator. Okay, testator is a Bengali probably.
Bengali, the property to be bequeathed is in Calcutta, Salt Lake, Calcutta. So,
Okay.
the executor
He
is
last
also from
resided
Calcutta.
at- he last
Everybody is in
resided at
Calcutta.
Puri.
But he last resided in Puri. The testator
How
last
many, for
resided
how many
in Puri.
years?
My lord, my instructions are, my lord, at the time of preparation of the will, in the will also, my lord, it is written he is presently residing in Puri.
That is which year the will was prepared?
2007, my lord, in 11 January 2007.
And the legal heirs are residing in Calcutta.
The legal heir is in Calcutta, which is the only son, and
So
the
you want a
property to be bequeathed is
want
also
a-
in Calcutta.
No, you want a clarification to this?
Yes, my lord. Either my lord may
English
change the
newspaper that
Bengali
will remain.
newspaper to an Oriya newspaper, or
English newspaper will remain.
yes, my lord. Bengali may be changed to Orissa, or my lord, the testator last resided may be changed to where the property is situated. Otherwise, my lord, there is a difficulty with the publications.
No, whether any relations of the testator were residing at Puri or not, whether
Could
he
be,
had
my
a
lord,
property
so-
there.
No, my lord. None of the properties to be bequeathed is in
Where
fact,
he resided? Where he resided?
he resided in Calcutta.
No, you are saying that at the time of bequeathing the property, executing the will,
Yes, my
he
lord.
was at Puri. It is a registered will.
No, my lord. It's a notarized will.
Okay, so he was residing there. So where he was residing, if he did not have any property or house?
He was residing, my lord, in Belia Panda Puri, my lord. He may have had property there. My lord may keep it as one English newspaper and one Oriya newspaper, my lord. instead.
Yes, record an order. Learned advocate for the petitioner is present. In terms of order dated September 2, 2025, a direction was issued to make necessary publication in one English newspaper and one Bengali newspaper widely circulated in the locality where the testator last resided. Stop. It is submitted by the learned advocate for the applicant that the testator last resided at Puri. Stop. In the facts and circumstances, order dated September 2, 2025 stands modified to the extent that instead of Bengali newspaper, it should be one Udiya newspaper. Other contents of the order dated September 2, 2025 remain unaltered.
I'm grateful, man.
Number 4.
But as per my lord's desire, the matter was sent to mediation. Mediation, my lord, has not
Lokadala.
rectified. Yes.
Your Lordship, I am being led by Mr. Banerjee. If a passover may be allowed for
My lord,
5
this has
minutes.
been an usual practice. My lord, this is really, my lord, I'm strongly
No,
opposed.
Lordship,
My lord, every day, my lord, this has become a
No,
practice, my lord, in this matter. Since, my lord, we have
Yes,
reached the point of maintenance.
Are you
I
ready?
must, yes, Miller, I am appearing on behalf of the award holder.
Okay,
Your
let me
Lordship,
see.
kindly see the last order, Miller.
Yes.
An award holder, my lord, is a document holder. There is no award.
Kindly have a look at the last day's order, Miller. By your Lordship's last order, by the consent of both the parties, Miller, the Lordship was pleased to direct us to
Anyway,
appear
the
before-
matter, the
Kindly
settlement
hear-
failed.
Kindly hear. We went to the National Lok Adalat
Yes.
under the hope that there is going to be settlement. Milord, I am a person who is supposed to get more than 1 crore. By an award which has been passed, the award is deficit as far as stamp duty is concerned because the MSME didn't
Oh,
have
if
the
you are,
procedure.
if you are ready before
Now,
the.
I have two things to say, Milord.
Yes.
I have two things to say because before I came, I heard that there are certain things which was being told regarding the award holder. Milord, when we approach the National Lok Adalat, Milord, it is under an assumption that there is a scope of settlement.
Yes.
The matter was taken up at the very first session by 10:30, 11. Nobody appeared. We waited. Even the judges waited. And at the end of the session, Milord,
Record this submission.
yes,
My lord, he
and
is
the
making
end of the-
submissions
end
with
of the
regard to
session, Milord,
mediation, which is, my lord, deprecated by the Honorable Supreme Court. My
at
lord,
the
if my
end-
learned
at
friend
the
is
end of
making
the
these
session, Milord,
submissions,
we were
kindly record
informed
these
that they are
submissions.
not-
My lord, will take
they
it
are
up
not
to
agreeable to settlement.
Yes.
What I only say,
He cannot, my lord, make his, my lord, statements in court, my lord, with regard to settlement.
Milord, what I
He is, my
only
lord,
say,
debarred by law.
what I only say is if they are not agreeable to mediation or settlement,
Kindly record, my lord, this statement that, my lord, he is
Record,
taking settlement here, my lord, to prejudice
No,
your
no,
lordship.
Are you,
This is, my lord, just
are
not
you
done.
ready to do the matter before the vacation?
I am. But I am only saying that if nobody is ready to settle,
No,
then
no, the
why
matter
do we
has
give a false hope of settlement to delay and
Let
delay
the
execution
let the
procedure?
matter be taken up.
Let me, my lord, take this, my lord, by the.
Yes,
Milord,
record and order.
I only say, Milord, one.
My lord, there is no award, my lord, till today.
you cannot-
2021 execution application
Matter-
filed without there being an award.
Matter can be sent to Lok Adalat or mediation for the purpose of settlement.
Yes, I was agreeable.
But neither the
My client
court,
was there.
you see, neither the court, neither of the parties can
Nobody can
compel others.
Nobody, but this should
If-
be
My
a
lord, these submissions
mechanism
are
to
only, my
delay.
lord, to prejudice your lordship. My lord, my learned friend has taken
should not be
adjournment
a
day after
mechanism.
another.
their intention
Kindly see
is
the record, my
not
lord.
to delay. Their intention is not to delay.
No, it's just the reverse. They are the decree, they are the award debtors.
My lord, kindly hear the matter today. My lord, we are ready. Kindly hear the matter today.
Conceded.
Learned
We will
advocates,
never, my lord, get the matter
for
heard.
the parties are present, it is submitted by the learned advocates that
No, Milord, kindly send this for
Although the matter-
rectification, Milord, payment of.
That can't be
debt
done
and
after
duty.
3 years. Can't be done. My lord, that's barred by law.
the
Milord, then kindly
Can't
ask
be
us
done.
to hear out the matter.
although
Can you
the
hear out?
matter, just a minute, let me
Yes,
record.
Milord, as your lordship.
Learned advocates for the parties are present. It is submitted by the learned advocate that although the matter was sent to the National Lok Adalat by order dated 4th September 2025, but the settlement failed. In the facts and circumstances, let this matter appear for hearing on 23/9/2025.
So grateful to your lordship, sir.
Yes.
So grateful.
Let the records be put up on the said date.
Milord, in the
Grateful.
meantime, if your lordship
Grateful.
wants, Milord, I'm renewing this submission. On the last occasion, I made the same submission.
No, I shall hear you on 20.
Because, Milord, the deficit stamp duty can be cured. It's a
That
curable
can't be
defect.
cured, my lord, today.
If that has been objected,
It's
then
barred
we
by
will
law.
argue that matter.
It's my lord,
Anyway,
barred.
you argue the matter on the next day.
Very well.
I've kept it on
After
23rd.
5 years, my lord, it can't be cured. রাখুক না, কিছুই তো হবে না।
I'm deeply obliged.
There's no award. Grateful.
Item number 5.
That I appear for the decree holder. This is appearing at our instance, my lord, for some, my lord, corrections, my lord, which are necessary in the order passed by your lordship on the last occasion. My lord, this was the order as it stood, my lord.
So what correction is to
My
be
lord,
done?
corrections I have taken the liberty of indicating that in this, my lord. Kindly sees this, my lord, in red ink. I have taken the liberty of indicating the corrections. And I have, my lord, shown a copy to Mr. Sinha as well as Mr. Bagh. My lord, first, my lord, the appearances, there are certain corrections. In the first paragraph, lordship, decree holder number 2 won't be there because decree holder 2 is dead.
1 and 4. Only 1 and 4 or 1, 3 and 4?
No, decree holder 1, 3 and 4 remains.
Mr. Bagh is for 3.
3. I was representing 1 and 4. That correction in the, my lord, recording of the appearance is also necessary. Then, my lord, first page, the second last line, instead of B oblique A, it should be P oblique, my lord, L. That's the correction. And, my lord, internal page 2, my lord. My lord, this we want an inclusion because lordship has directed sums to be realized from, my lord, the account maintained by RBI. My lord, the account name is not there, my lord. It's from land acquisition collectors account requisition. These are the, my lord, corrections which are necessary, my lord, to implement this order.
Lord, I Lord have Lord, with regard to corrections, Lord, it is Lord, entirely for your lordship. Lord, only one thing, Lord, which I wish to Lord, submit before your lordship, and your lordship may kindly be pleased to record it. Lord, after this order Lord, has been passed, Lord, have been informed by the department, Lord, there are serious Lord, disputes with regard to the calculation Lord, of the awarded amount. Now, my lord, when this happened, Lord, because I did not have the instruction, Lord, I did not Lord, make any submissions on.
This matter is not disposed; it is kept pending.
Yes,
and
yes,
8
yes.
weeks the money
So,
will
can
lie
you
with
record my submission, Lord, that I've been instructed, Lord, that there's
come with necessary application.
we'll file appropriate applications with regard to that.
My lord, before your lordship starts dictating the order, my lord, we have, my lord, been granted leave by your lordship, my lord, to file the application. May I only pray for leave for short service so that, my lord, this matter may be coming up maybe tomorrow if it pleases your lordship. Only for this much, my lord, that paragraph page 20, the order which has been passed by your lordship, page 2
you
of
pray,
the order.
you make a prayer on the next when the matter will be taken up, or any day.
Attachment is already there, my lord. Can you not pass any further order?
Application is ready, my lord. We have been granted leave by your lordship, my lord, to file it. I'm only praying for leave for short service.
That can be taken up on any chamber day. That is merely a leave. For that, no order is required to be passed.
It will come after 2 clear days. That's the
Anyway, after if you mention it, that is tomorrow, Thursday, it will come up on Tuesday.
We'll do some.
Yes.
We'll do some.
Learned advocates for the parties are present. Learned advocate submits that some mistake is detected in order dated 11th September 2025, which may be rectified. In the appearance column of the learned advocates, instead of decree holder number 1 to 3, it should be decree holder number 1 and 4. With regard to the appearance of Mr. Pranit Bagh, advocate, and Mr. Ramanuj Roy Chaudhary, advocate for added party, it should be decree holder number 3 instead of decree holder number 4. In the first line of the order, after this sentence, learned advocates for the decree holder number 1, decree holder number 2 should be deleted. In the last but one paragraph of page 1, instead of BA account B stroke A account, it should be capital P stroke capital L account. In page 2, the last line, it should be included decree holder number 4, MS Arundhati Chatterjee, from land acquisition collectors account requisition. Stop.
My lord, kindly comes back to page 1 once. My lord, just before that account number, it should be requisition, not requisitioned. That's, my lord, the name of the, my lord, account. Collector's account requisition. ED should be, my lord, omitted.
In the in page 1, in the last but one line, it should be collector's account requisitioned. ED.
ED should not be there.
Yes, it is there.
No, my lord, it should be requisition.
ঠিক আছে, PL অ্যাকাউন্ট ও ছেড়ে দিন, যা ওখানে দেওয়া ছিল কি BA অ্যাকাউন্ট, ইট শুড বি PL অ্যাকাউন্ট, and instead of requisitioned it should be requisition, REQUISITION. Other contents of the order dated 11th September 2025 remain unaltered.
My lord, may I only renew the prayer to this extent? My lord, tomorrow is the chamber day, my lord. So, my lord, otherwise we'll go to
No, I think it is
vacation.
to be moved in chamber.
My lord, that's the reason. Lord, if that leave is granted today,
Question is, okay,
it will come up in the, my lord, it will come up tomorrow. That's the difficult.
you take it, you see chamber application leave is granted on the chamber day.
My lord, today if the leave is granted, my lord, it will come up tomorrow. That's the difficult.
Question is, you see, question is in Thursday, on Thursday, many chamber matters will be taken up. Thereafter, we are getting 2 more days time. That is Tuesday and Thursday.
But this is also a chamber day, my lord. So again, next week we're very
Very
close to the
well.
vacation.
Next
That's the
day,
reason.
2 days, you are getting time.
We'll do that. We'll do that.
Acha, Mr. Sinha submits that some corrections is to be made with regard to the awarded amount and the calculation which is disputed by the decree holders. However, the parties are at liberty to make necessary application.
Deeply obliged, my lord.
হ্যাঁ, এবার ফর অর্ডার্সটা দেখে দিন একটু, ফর অর্ডার্সের পরই 10:30টার ম্যাটারটা। হ্যাঁ, এটা আছে ও আগের অর্ডারে যা রিটার্নেবল ডেট তাই
10:30টার ম্যাটার আছে।
ফর অর্ডার্স, কল দ্য ফর অর্ডার্স
Item
ম্যাটার্স।
number 41, special fixed matter.
Yes.
Mr. Mitra is coming.
No, whatever it is, today Mr. Dotto will submit.
We have submitted, I just want to add
Yes, yes,
to recapitulate your lordship's memory
yes.
that the present application is an application under order 12 fixed for judgment upon admission.
Yes.
Lordship may recall that the suit was filed for my eviction on the ground of trespassing. And the suit, the application which was filed on the alleged ground that I have admitted that I am a tenant, and that is why my father has died 5 years back, and therefore section 2G of the
It is. On the last occasion, you have submitted with regard to some of the decisions also.
decision is covered by your lordship. So, my lord, I submitted that the admission, judgment upon admission means admission of the case made out in the case made out in the plaintiff is a trespassing. So therefore, I have not made any admission in my statement or otherwise that yes, I am a trespasser. Had I done so, my lord, then definitely the judgment upon admission would have been entertained. And I had also cited a judgment of your lordship that a purport of the suit cannot be changed from rent tax.
No, no, these things will also be reflected in your comprehensive written notes of arguments and compilation, okay? Whatever you have submitted, any other, in addition to this, anything to submit?
That, my lord. So only on the point of law they will make their.
Yes.
Like, there should not be any re-argument of them.
No, 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 no. Only the reiterating means on the points of law and thereafter written notes.
So because Mr. Kakkar had made their his submission in details for 1 or 2 days on this, and I have given my answer.
Yes, what shall I do? Shall I pass it over?
My lord, your lordship pass over.
Yes?
Pass over, my lord. Let Mr. Mitra come, my lord. It's my fault, I can admit. My lord, counsel is on legs.
Okay, pass over.
Pass over, my lord.
Let them write their notes and you covered up everything, my lord.
Anyway, I am giving them one more opportunity.
New motion, item number 6.
My lord, I approve for the respondent, official concern.
Lord, I am for the petition, my lord. My lord, this is my
Whose application
application,
is
my lord,
this?
under the official trustees acts, my lord.
Asked while of.
No, no, item, this GA6, GA4, whose application?
GA4, my lord. GA4, my lord, is my application, my lord. My lord,
Yes.
initially, my lord, what has really happened, my lord, is that with regard to, my lord, several irregularities, my lord, in the office, my lord, of the official trustee, my lord.
But we file an application, my lord. My lord, essentially,
Affidavits
my
are
lord,
exchanged in this
affidavit has
matter.
been exchanged, my lord. The erstwhile official trustee has also, my lord, given their affidavit, my lord.
Yes. Yes.
He was not a party because he was at that point of time he was the official trustee. Then subsequently an application was making leveling some personal allegations against the official trustee in course of this process.
No, what is this application? In this GA4 2023, this order is passed.
So that this order has been passed, my lord.
Now GA4 was that application
My lord, GF4, my lord, is my application, my lord. With regard to my lord, if my lord, can I take the application, my lord? My lord,
they are looking at of the trust. Now it includes jewelries. Jewelries are kept in the deposit inside there's a locker room in the office of the official trustee. Wherein in a separate box, all the jewelries are kept of various trusts. An inventory was carried out by Indian official trustee in respect of various jewelries and all. So they made an allegation against the official trustee that without their permission and without permission of the court, how could the official trustee not carry out accidentally and open the jewelry? Then subsequently, they wanted according to the subsequent allegations that these jewelries were all gold jewelries are now same jewelries are there, which were gold are now silver, etc. These allegations are there. In the meantime, agency of this application, an application was filed by them. This official trustee who was at that point of time has since been transferred. He is a judicial officer. Transferred is now again sitting judicial officer. So an allegation was made in an application filed by them for leveling certain personal allegations against the particular
The judicial officer.
judicial officer.
But I submitted that since this is a personal allegation at the personal level, he should get an opportunity to deal with it because he is no more the official trustee right now. So accordingly, the order of 14 January 2020.
What relief they have sought for in this application?
My lord, the relief, my lord, we have sought for, my lord, is that, my lord, to, if my lord may kindly take, my lord, my application once, my lord, at page 7, my lord.
Yes, you want to say anything?
In this matter, my lord, Percival has also passed it over, or I will be engaged in some other court, my lord.
Anyway, you are
Please, my lord, some other day, my lord, kindly.
it's a
I had accommodated my lord.
Mr. Mitro was subject. Mr. Mitro saying 4 times.
4 times this accommodation has been given by your lordship. I also agree. I am not standing in the way of Mr. Mitro. He will come whenever he will like. But today, my lord, kindly not take it up.
So let me take it up tomorrow.
Yes, tomorrow.
But it has to be concluded. আচ্ছা এই কালকে ইয়ে আছে কিছু 2 PM এ দেখুন তো
My lord, kindly keep it. Don't fix up any time, my lord. Kindly.
No, it has to be concluded after all, otherwise
আজকে তো 10:30 ছিল কোথায় তার আগের দিন ছিল তো time is fixed.
you see I have fixed the time so that there is some interest to come and do the matter.
Today also the time was fixed.
2 PM এ আছে কটা আছে একটা আছে ওটা কি witness action. Okay, I'm keeping it tomorrow at 2 PM. Acha, let this matter appear. Mr. Dotto, learned advocate, counsel for the defendant defendant applicant has concluded his submission. Oh, sorry, defendant opposite party has concluded his submissions. Let this matter appear on 18/9/2025 at 2 PM for reply of the plaintiff.
I admit, my lord, this is my fault.
Yes,
for the
but tomorrow, you see,
My lord. My lord, my application.
what is the relief sought for in the
But the
application?
relief,
Let me
my lord,
see.
that we have sought for, my lord, is that, my lord. My lord, my application, my lord, may I submit? My lord?
Yes, no, let me see your application. Oh, you are praying for not today.
She is appearing for the husband. In respect
So let it appear after vacation, okay, before, yes.
One,
Record an
my
order.
lord, they have, my lord, the erstwhile official trustee, my lord, has filed an affidavit, my lord. My lord, I need to deal with
Some
that affidavit.
instructions is required to be obtained. Reply is also filed to
No,
that.
my lord, to their affidavit, my lord, I need to file an affidavit, my lord.
No, affidavit in opposition is filed by the official trustee.
No, my lord. affidavit, my lord, my application, the official trustee has, my lord, filed affidavit
You are
opposition,
representing the present official trustee.
present official trustee, my lord.
And
And, my lord,
so far-
he is, my lord, representing
so
the
far
erstwhile
Mr.
official
Chatterjee, the former official trustee, Mr. Chatterjee. Oh, Mr. Biplav Roy. Yes. Now the former official trustee, you are representing the former official.
Since there are personal allegations, I submit to the audit report.
Yes, learned advocates for the parties are present. Time is sought for on behalf of the former official trustee. The matter stands adjourned till. Shall I keep it on the reopening date?
1 week after.
Someday.
Let this matter appear on 4/11/2025.
My lord, one, my lord, the erstwhile official trustee has, my lord, filed an affidavit, my lord, dealing with my allegations. My lord, I need to deal with some of, my lord, the
Yeah.
contents of their
Reply.
affidavit, my lord.
In the meantime, affidavit
Affidavit
in
may be-
reply may be filed to the affidavit in opposition submitted by the official trustees.
Erstwhile official trustee, my lord.
4/11.
Next is the following.
Okay, 11/11/2025.
Grateful, my lord. But in the meantime, my lord, the affidavit may be exchanged.
This is, I have granted you the liberty to file affidavit and serve a copy.
No, no, no more affidavit.
Item number 7.
Notice of motion টা দেখি। নোটিস অফ মোশন ফাইল করেনি হতে পারে নাকি? নোটিস অফ মোশন Okay, not today.
Item number 8.
6.
So why it is defective?
Well, and I'm appearing on behalf of the respondent, Lordship.
Year 286. You are for the applicant.
These matters are actually returnable on 24th of September, so far as I remember. My lord had the occasion to hear these matters. I was present on that day.
And Lordship, interim order has already been extended till the returnable date. Now, the difficulty is in the
Looks into my lord's last order.
No, affidavits are exchanged. In
this application, no.
So what is
This is appearing for the first time.
This is for vacating the interim order.
Lordship.
application? 286 is my application.
Okay, vacating interim order.
Yes.
Oh, where?
My lord, the interim order. My lord, takes my application at page 39. my lord.
Page 39.
Lordship.
What is that order?
My lord, this is an order, my lord, wherein, my lord, my clients were restrained. My client who are the my lord, purchaser of property from the joint receivers, my lord, have been restrained from my lord, indulging in any further, my lord, activities in the land they have purchased.
Okay, there is a defect. Okay, cure the defect. I am keep and let it be put up on the next day. Yes, record an order. Let the defect be removed and the matter be put up on the next date.
The difficulty is, my lord, in the presence of an interim order, they are still demolishing the walls and everything. It's not right.
No, interim order is there at
I
present
mean, payment
by
of
Justice
the-
Patronayak.
Yes, yes.
Passed an interim
Yes,
order.
yes.
Well,
Protecting
my
me.
client from the joint receivers.
However, that is a matter of
Nobody, my lord. Someone has come.
maybe, but when there is an order of the court, that should be followed.
Yes.
That is not being followed. We have lodged a complaint before the police. Hopefully, we'll come up with a content application as well.
Your lordship is keeping on 24th.
No.
And in the event that is taken care of, my lord, we'll like
Let
to
the
file a
defect be
opposition as
removed
well.
and the matter appear on
Let it be there on
22.
24th. 24th, the matter is already there. The other matters, lordship.
Why? What is this matter has
No,
to do
no,
with
no.
other matters?
Very well.
22nd.
2022/9/2025.
I'll move it on.
Matter that has been fixed by your lordship.
No, whatever it is,
Now,
all matters are
if
have to be taken care of.
the defect is cured, my lord, we will like to file affidavits through this as well. So let my learned senior friend come.
Before that election is passed, I have to move my application.
But
Yes,
but
yes,
unless and until the
Yes, you cure the
the
defect,
pleadings are
thereafter the
complete,
matter will be put up.
unless and until the pleadings are complete,
I have to
it
move my
can't be, my lord.
Yes.
After that, your lordship will pass.
Number
Bye.
9.
Your Lordship, I am for the petitioner in this matter, my lord. This application has been made on behalf of the added defendant, Your Lordship. What had happened, there was a suit for injunction, and in an application, my lord,
Yes. This is your application.
this is my application, GA 16, Your Lordship.
Oh, other parties, other side is not here.
Your Lordship, we had served at the time of filing the application. My lord, this is a very technical
Okay.
application. What had happened is, Your Lordship, an application was filed for recalling, which was dismissed for default. We filed a restoration application.
Yes.
When the restoration application was taken up, at that point of time, the Honorable Court was of the view there are certain technical defects, therefore amendment needs to be carried out. So we filed an amendment application to the restoration application.
Yes.
Now, and which was allowed. Thereafter, my lord, while carrying out the amendments, what has been noted by the department, Your Lordship, that the annexures, that is the restoration application to the amendment application, were draft copies and not the filed copies.
Okay,
So
that
this,
means you see, whatever order is passed, that is 26 July 2024 in GA 15 of 2024, that could not be carried out.
that could not be carried
So
out.
that time has to be extended to carry out
That time has to be extended, my lord, and leave has to be granted, Your Lordship, that the annexures C and D in this application at page 63 and 93, which are the filed copies of the restorations, be treated, my lord, as annexure B and D to the amendment application. Then that would correct the defect and would help carrying out the amendments, Your Lordship. My prayers are at page 6 and 7, my lord.
So motion to think.
Master summons.
So how this is by master summons?
Yes, Your Lordship, by master summons.
No, question is, if it is a master summons, there should be an affidavit. So it is a chamber
Lordship,
application.
This is a chamber application.
Chamber. So it should be, there should be an affidavit in support of master summons. So how in this format?
Your Lordship, my affidavit is at page 8. My lord, what happened? Affirmation is at page 8.
Order was passed in chamber. The earlier order of restoration.
Your Lordship, at that point of time, my lord, no separately, chamber applications were not taken up separately in this way, my lord.
No, question is, you see, your amendment application.
I am asking for this amendment application to the restoration application. I'm just asking for those technical defects to be removed, my lord, so that the amendments can be carried out. That is my small prayer. The order dated 26 July 2024 could not be complied, my lord, because of that.
Yes, which is the annexure of this GA13?
GA13, my lord, is at page 17 of my application. That is the restoration application. And GA15, my lord, is my amendment application at page 9. My lord, there is one more difficulty, my lord. That is in the prayer, my lord, I would also require leave for a hand correction because there is a typographical error. In the prayer A and C, it has gone down as GA13. It will be GA15 as
See,
per.
there will be again some problem.
Which
Better
is
you,
why if your lordship gives
you
grant.
better file afresh then. So many. First of all, this is an application for rectification amendment. Again, at the top of that, you want to rectify, and then you see it is not in the proper format. Probably it should be affidavit in support of the master summons.
Your lordship,
It is to be
may
taken
I
up in
humbly
the.
beseech?
It is to be taken up in the chamber. So many irregularities are there. So it's better I grant you leave. You take out afresh. Let it appear.
My lord, only if your lordship kindly grants me leave to make this correction by hand, my lord, only one difficulty, only GA13 number will change to 15. That is all, your lordship. If that leave can be granted and this prayer is allowed, it could be carried out, my lord. And there is a master summons also taken out with this application. My lord, I'm aware it should be in an affidavit format, but what has been happening
It is to
lately,
be
my
moved
lord.
in the chamber also.
Yes, my lord. If your lordship so pleases, if your lordship kindly keeps it tomorrow.
Yes, record an order. Let this matter, learned advocate for the applicant, plaintiff. You are for the plaintiff.
I am for the added defendant, your lordship. I am the
Okay,
applicant
learned
added
advocate
defendant.
for the applicant added defendant is present. None appears for the opposite parties. Let this matter appear on 18/9/2025 under the heading New Chamber Application. Yes, you come with a gist of what is to be done. Where are the rectifications tomorrow?
Do I have to write it down technically?
Yes, write it out. And what leave you require? Which prayer you want leave to rectify? You give a gist tomorrow.
My lord.
And inform the other side also.
My lord.
Item number 10.
10, I appear for the petition. Now, this is a suit for partition of 1988. 4 properties were involved in the partition suit. 3 of the properties have been sold or purchased by different co-sharers. Only one property at Siddheshwar Chandra Lane, just opposite to the medical college.
Applications were moved, I think.
Yes, my lord has heard it. I will just give a background, my lord.
What is this application now?
Yes, my lord gave me a leave, my lord, and that's the result of this application.
So serve
Now,
other side and come.
we have served, my lord. We have served. Affidavit of service is on record. Now, I will just give your lordship the background, my lord. Only one property, that's Siddheshwar Chandra Lane, that's remaining where the petitioner is residing. Now, the condition of the building is completely dilapidated, cannot be repaired, my lord, beyond repairs, my lord. And if it can be repaired, huge expenses. My lord can see the photographs on page 47. Now, this property has been put up for sale. A special officer was appointed and a valuer was appointed thereafter. The valuer has found that 51 lakhs is the price, my lord, that it can fetch. Now, since I am the person who is staying in that property, I intend to buy this property. On the last...
You are the defendant intending purchaser.
Defendant intending purchaser. Since I am that's my shelter, I want to buy this property at the price assessed by the valuer. My lord will kindly see the report of the valuer. That's page 63. That's recorded. 63. Bottom. It is found that the valuer's report that the property in question is valued at 51,72,000. I want to buy it at this price. Now on the last...
When it was valued?
It was valued in 2025. 10 January, in January. At the recent valuation. Now, on the last occasion when this matter was taken up, page 65, your lordship will kind to come to 66, that's my lord. As the petitioner is ready and willing to purchase the suit property, liberty is granted to come with necessary application upon service of copy upon all
Where
the
is,
parties.
just a minute. 10 January 2025.
Yes, my lord. Yes, my lord.
Okay. Directed to cause publication. So that was done, this publication.
No, that is the point, my lord, because the title deeds of the properties are not available. So the receiver expressed that without a title deed, how can I put a property
There
for
was a
sale?
direction, you see, to cause publication. So this order has to be modified then by necessary application.
That has to be
I have
done.
to.
And now, before it goes for a publication, since I am willing to match this price, I want to buy this property at this price itself.
So this is not required.
So this is not required. This exercise would not be required, my lord, because I want to match the price which is been fixed by the value.
What is the reason to not making this publication in terms of the direction?
That is the point, my lord.
Because you see, it's an order passed by the coordinate bench. I have to accept this order, or I have to modify it under the new circumstances.
Yes, new circumstances, because that at that point of time I was not I was a little bit doubtful whether I will be able to arrange these funds of 51 lakhs too high for a central Kolkata person.
Publication for sale of the property.
Now I want to buy it, my lord. I have accumulated funds from, I've taken some loan to get it, because if it is sold to outsiders, I would be shelterless. I would be coming to the streets. But I will get only a share which I would be entitled according to the preliminary. So I want to buy it, my lord. I want to give the entire money. I want to buy it, my lord. That's my submission in the last day whenever the matter was taken. And my lord granted me leave that you file an application and serve it. We have served it. None is there to oppose my prayer also. Because all others have purchased their property, they are happily residing. I am the person who is saying, and my lord will kindly see the condition of the building also. Page 47 onwards. 47, 48. Every day portions are coming down, my lord.
Page 47.
But I am praying for prayers A, B, C, my lord. If I am unable to purchase, my lord, it can be put up for sale, my lord. My lord will kindly give me an opportunity to show my bona fide. If I am unable to purchase, I am unable to put in the money.
Keeping it on Monday. If none appears, I shall pass the order. Okay.
Monday. Then my lord, Tuesday. Monday I am not available. I will be in Delhi.
Tuesday actually is a chamber day. It becomes difficult. You see.
Monday
other than Wednesday.
Wednesday.
It's very limited before.
Yes, I understand.
Otherwise, I can keep it after vacation.
No, not vacation, my lord. In the meantime, during this puja vacation, my lord, I will put in this money. 51 lakhs too high for me. I will arrange it and put it during this vacation, my lord.
Yes, record an order.
Okay, sir.
Yes, can you on Friday I can also keep it.
This Friday?
Yes.
I'm available.
Every
day I don't get a outstation.
Learned advocate for the petition at defendant number.
Defendant number. I will just give you. 4C. 4 within brackets small c.
4C. Applicant is present. Hard learned advocate for the defendant number. Learned advocate for the applicant. None appears for the opposite parties in spite of service of notice. However, in the interest of justice, this matter stands adjourned till 19/9/2025. It is made clear that in the event none appears, the matter will be taken up in their absence. Learned advocate is requested to serve notice upon the opposite party. Learned advocate intimating the next date fixed. You just intimate, I shall take it up on 19/9.
I will give a notice.
Other side advocate?
No, none is appearing. This issue is going up for the last 1 year. 2023, when the part portion of the building collapsed. We gave notice to all parties, accepted notice, none interested to come before the court.
I've kept it on 19/9. If none appears, the matter will be taken up in the
I will kindly record that. If none appears, it's not necessary. Grateful. 19. I will bring some. I'll try to bring some money also. If I don't know, I will give me a direction. I will give.
No, regarding honest money.
Honest money.
Okay, okay, that I shall consider.
On
Who is the special officer at present?
Mr. Das, Mr. Das, Ratul Das, a
Okay.
member of my friend.
Item number 11.
My lord, this matter pertains to a restoration application, and the application there is also a condonation of delay.
For?
I'm for the petitioner, my lord.
Let me see the order application.
My lord, the condonation of delay is not appearing in the list. My lord, I'm requesting your lordship
What
to
is the GA number?
GA 14 of 2025.
Okay.
Only
When was
GA
this?
13
How
is
many days delay?
more than 2000 days.
Did the other side file their affidavits?
My lord, I don't have instructions on that.
Acha, let GA. What is the other case?
GA 14 2025.
This is GA 14 of 2025.
Is it like? But my lord, only GA 13 is showing in the list.
No. Cases GA 13 and 14 both are here.
My lord, I'm praying for a short accommodation than a day's accommodation, my lord.
Okay, not today.
Grateful.
Have you served?
Yes, I need to get
Where
it
is the
checked.
affidavit of service?
The advocate on record is on his legs in code number 11. So I am.
No. Question is, have you caused service? Are you his junior? Who is the?
No, my lord.
Okay, not today.
Number 13.
Honestly,
13, 14. 13 or 14.
Yes, item number 12.
Well,
the Sanjay Jhunjhunwala is appearing for the defendant.
Whose application is this? GA 14.
No, it's the plaintiff's application. Mr. Shorkar was moving this application, Shankar Sen Shorkar.
Lordship, Mr. Jhunjhunwala's
My lord, my application for my lord appointment of receiver. I have my lord some urgency. My lord, if they are my lord praying for my lord any personal reason, my lord, then my lord I cannot stand in the way. So if your lordship my lord kindly my lord defers it for maybe a week, my lord, thereafter my lord
I can keep it on Monday.
My lord, as my lord my learned friend my lord can.
Yes. Learned advocate for the plaintiff applicant is present. An accommodation is sought for on behalf of learned advocate appearing for the defendant. The matter stands adjourned till 22/9/2025.
But will it be your lordship's pleasure to my lord keep it at some time?
It is
If it so
appearing under the
commences.
heading new motion. Okay.
It will be at the top.
Yes, new motion, it will be taken up.
I'm so grateful. So great. Appearance.
Item number 13.
Your Lordship, this is my application for change of receivers in the matter. Lordship, it's in respect of a property located in Bada Bazar. There was
This is GA 20.
20, Your Lordship.
What is your prayer?
Lordship, for change of receivers.
Yes, what is the grounds?
Your Lordship, the earlier advocate on record of the plaintiff has given a change. The advocate on record of the plaintiff and the defendant number 7 were the joint receiver in respect of the property. Your Lordship, the name of the plaintiff's advocate has to be changed. Your Lordship may see the last order at page 24.
Page 22.
24, Your Lordship.
24.
देखिए
Okay, so in terms of that order, learned advocate for the plaintiff and learned advocate for the defendant number 7
Your Lordship.
were appointed as the joint receivers.
Your Lordship. Your Lordship,
Namely, that is Mr. Anirban Ghosh and Mr. Rajesh Upadhyay.
Your Lordship. Now, Your Lordship, Mr. Anirban Ghosh has given a change in the matter.
Change in the matter, that means he is no more acting.
No more acting.
So who is appearing?
Your Lordship, I am appearing. So we have made a prayer that my name and Mr. Upadhyay was appearing for the defendant number 7. His name be substituted as the receiver in respect of the property.
Okay, so far Mr. Anirban Ghosh's name can be substituted.
Your Lordship.
And so far Mr. Rajesh Upadhyay is concerned?
He will continue.
I remain as the joint. Or if you want, I can appoint a third party receiver also.
Your Lordship, the problem was that the property is not yielding money, and the plaintiff and the defendants were not willing to bear a lot of cost.
Question is, exorbitant, huge remuneration cannot be given.
No, Your Lordship may not provide for any remuneration at present. Your Lordship may give a token if Your Lordship deems fit.
Remuneration, and thereafter, upon necessary.
That's why, Your Lordship, if the advocates on record continue, they will take more steps because, Your Lordship, the building is very dilapidated.
No, advocates will extend necessary cooperation, but these two receivers, I cannot direct to pay monthly remuneration or something.
Your Lordship,
at present, some remuneration, and thereafter progress 6 months or 7 months. Thereafter, depending upon the collection, some remuneration can be provided. That is why that would be better, I think, by giving a third party, so that even if advocates change, there will be no problem.
Your Lordship may consider it because, Your Lordship, since 2012, the advocate on records have continued from time to time for some reason because of this only. The
Now
problem
you
in
are
paying.
you are there. You are continuing.
There, I would beseech your lordship that the status remains. I mean, it's up to your lordship, but if both of the advocate on record is there, be beneficial. That is what the instruction is also.
Yes, record an order. Learned advocates for the parties are present. This application is filed for replacing the former joint receiver, Mr. Anirban Ghosh, learned advocate, and Mr. Varun Kedia,
Your Lordship.
advocate.
Your Lordship.
Okay, both have given change.
No, Your Lordship, I am appearing in the matter now.
No, question is.
Mr. Ghosh has given change.
Okay. Anirban Ghosh, only Mr. Anirban Ghosh, who was appointed joint receiver along with Mr. Varun Kedia.
Rajesh Upadhyay.
So why this is mentioned? And Mr. Varun Kedia, advocate?
No, Your Lordship, that is the prayer that I be substituted in his place.
Okay. And be discharged. It is the contention of the petitioner that the former advocate, Mr. Anirban Ghosh, is no more appearing as an advocate for the plaintiff, and he has given change. In place of Mr. Anirban Ghosh, Mr. Varun Kedia has been appointed as learned advocate for the plaintiff. Give in VARUN KEDIA. Yet the notice of motion. Upon hearing the learned advocate and upon perusing the petition filed, this application stands allowed. Let there be an order in terms of prayer A, B, C, and D of the notice of motion dated 17th day of July 2025.
Your Lordship, only one prayer. Your Lordship, there is a bank account with Punjab National Bank. The problem which Mr. Ghosh and Mr. Upadhyay earlier faced was that they could not substitute their name in place of Mr. Gupta, who was the earlier receiver, because earlier the account was a single account. And when two receivers were appointed, it became a joint account. If your Lordship provides the bank
Yes, the bank authorities will take necessary steps with regard to the accounts at presently held by the joint receivers in terms of this order.
Your Lordship, the account is still being held by Mr. Gupta, who was the receiver who has retired long back. So the
bank authorities are directed to
Your Lordship may give the account number. It is mentioned in
necessary
the prayer.
steps with regard to bank account number 0091010413718 with Punjab National Bank High Court branch in terms of this order. Yes, now it is clarified.
I hope so. Otherwise, Your Lordship, I'll have to come back.
Yes.
Great, great.
No, they disposed, application disposed.
For orders, item number 14.
This is that probate matter, a non-contentious cause.
Yes, this application stands allowed. Probate of the last will and testament dated 21st February 1997 of the deceased Pashupati Nath Banerjee is granted to the petitioner as executrix to take effect throughout the state of West Bengal. Let probate be issued upon compliance of all necessary formalities.
Grateful.
Disposed.
Item number 15.
Yes. Thus, this application stands allowed. Probate of the last will and testament dated 21st February 1997 of the deceased Pashupati Nath Banerjee is granted to the petitioner as executrix to take effect throughout the state of West Bengal. Let probate be issued upon compliance of all necessary formalities. Okay. Grateful. Disposed.
For framing issue, item number 16.
So this is that matter, my lord, where I am agreeable, my lord, to the plaintiff's contention in the plaint. The property is owned by the plaintiff and my lord 5 and 6. The division bench order is there, my lord, saying the appeal, the suit, my lord, may be heard because it's a 1976 suit. Now, framing of issues, my lord, for 3 days, my lord, my learned friend has taken extension.
My lord, I appear on behalf of the plaintiffs, my lord. I am led by Mr. Shudhashatto Banerjee. My lord, may I just say this? There is one contesting defendant. The last 2 occasions why we took adjournment for framing of issues, my lord, if your lordship recollects, it was because we were trying to figure out all the papers filed in this suit, my lord, because we were not having all the papers. Now, my lord, we have gotten all the papers, my lord, we've taken an inspection from the records. What transpires is this, that 5 and 6, Mrs. Banerjee is appearing. As far as defendant numbers 1 to 4 are concerned, my lord, a written statement has been filed on behalf of defendant number 1. My lord, thereafter, there has been no order, a formal order for transferring this suit to the list of undefended suits. Then there has to be a formal order transposing it to the undefended list. The only issue, because the contesting defendants are otherwise agreeable to all the issues or all the claims made by the plaintiff in the suit, there may not be requirement of framing of issues, provided the other defendants, as far as they are concerned, the matter is transposed to the undefended list. So my only limited pref for procedural reasons. I am the plaintiff. I also want the orders. And if a decree can be passed with Ms. Banerjee's consent, I would be the happiest plaintiff. But
Question is
difficulty to overcome that, Lord. And if they do not appear, Lord, your lordship can
No, how many defendants?
Lord, there are 6 defendants.
Lord, I'll tell your lordship.
There are 6 defendants.
5 and 6. 5 and 6. Yes.
Total.
3 branches. Defendant number 1 died and 1, 3, 4 came in their place. That is 1 branch. Who say that they are owners? They say they were supposed to execute a deed of release. 5 is me. I don't object. I say yes, I am the owner. He says yes, you are the owner. 6 also in the same position says I am the owner. Plaintiff also says yes, you are the owner. So 5 and 6 we have obviously filed our written statements, but we don't object to whatever goes on between plaintiff and defendant number 1. So the real contention or the issue is between plaintiff and defendant number 1. 1 has died, but there is a written statement which is on record.
So 1 has died and the
1 has died.
Representatives are substituted.
1 has not died.
Defendant number 1 has not died so far as
Original defendant number 1 has died.
Yes, that is original. I am talking.
Yes. Nonetheless,
So the heirs has come as 1A, 1B, and
no,
how the heirs have come?
1, 2, 3, and 4.
Lord, I am not aware about the deaths.
Yes, of course.
No, my lord, just correct. My lord, 1 to 4.
Where is the order recording the death of defendant number 1? And
No, my lord, there was no defendant number 1. There was no original defendant number 1, my lord. This was defendant numbers 1 to 4, who are 4 defendants of the heirs of late Nandlal Jalan, who Miss Banerjee contests has died, my lord. There is no defendant number 1 which had to be substituted. Now 1 to 4 are the heirs of that person, which is Nandlal Jalan.
Yes, Mr. Banerjee.
Now 1 to 4 have to be served.
Just 1 minute.
there are, as now at present, there are 6 defendants.
Yes.
Okay. So what your junior is contending, you are
No, she is as usual my other side. No?
Okay. You are for the different.
As always.
Okay.
We look near to him.
No, in some other matters you are. Now the question is, with regard to the defendant number 1, original defendant number 1, whether the original defendant number 1 died or not.
Original defendant number 1 has to substituted by the present defendants who are there.
That is 1, 2, 3 and 4.
1, 2, 3 and 4.
Yes.
Now this 1, 2, 3 and 4 have substituted D1. Out of the substituted D1 to D4, D1 has filed a written statement.
That is 1, present 1.
Present D1.
Present D1.
D2 to D4 have not filed a written statement.
Right.
D5 and D6 have filed a written statement. In all fairness, if I'm given to understand.
I am not opposing, I have already said. I'm not.
He's not opposing.
You are for 5 and 6.
5.
Five.
Well, actually, 5 and 6. Yeah.
You are not for 6. There is another
Okay.
person, Milord, who is for 6.
5 and 6 won't oppose. Well, 5 and 6 anyways get what the suit is that D1, original D1, was holding the property as my benamdar. He had purchased the property in his name and I had paid him the money. He thereafter signed a deed of release, which D1 was supposed to execute. Now, this is before the 1988 Act, so the prohibition under the Benami Prohibition Act doesn't apply. Now, D1, substituted D1 as filed. I was only praying for this. Somehow, there is no order for the suit to be made undefended with regard to D2 to D4. But only in the fitness of things, kindly direct a notice, issuance of notice upon D1 to D4 if they want to come and contest.
So this D1 has filed the written statement. So definitely D1 is contesting.
After that, D1 has disappeared.
That written statement.
For a long time, the advocates have not appeared.
Correct. Which is why I'm saying, my lord, in the fitness of things, a notice should be issued upon D1 to D4. If they thereafter don't appear, then I can actually beseech your lordship.
The learned advocate is representing D1 to D4, but the written statement is filed by only D1.
D1. Well, I will put D1 to D4 on notice again.
Right.
Carriage of proceedings lie with me. I
5
don't
and
want
6 are represented.
5 and 6 are represented by her. I don't want a situation where I get a decree against D1 to D4 and later they come and file a recalling before your lordship. It will be a waste of your lordship judicial time.
Permission was required for this, Milord. My learned friend would have, Milord.
No, Milord, I could not have. If order 9-7 comes in,
there is no shortcut.
Correct.
Milord, 3 days, yes, Milord, waste. 3 days, Milord, adjourn.
Anyway, Mr. Banerjee was not there.
There are other matters where I see people waste more money. She is in one of them. Well, kindly give directions for issuance of notice. We can come back immediately after the vacations. In the meantime, if they want to take steps, they'll take steps. Otherwise, we can just proceed and have the probably suit decreed against. Because two parties are me and Bibi both.
The only thing, Milord, is that he has taken a stay, Milord, on the property. So that nobody can deal with it. That is the problem. All along, Milord, my learned friend was not enjoying any such right. But I conceded, Milord, before the Honorable Division Bench and said, very well, let it be stayed. I will also not deal with it. He will also not deal with it. Under the, Milord, I was under the presumption, I was taken to believe that he will proceed with the suit.
I am.
So today, Milord,
Milord, she must understand that I'm doing this. That will help both of us. It irons out these procedural difficulties that may arise if we get the decree. If we waited from 1976, correct.
Anyway,
let this notice be issued, Milord. It will create.
Yes, record
this hurdle will be able to overcome.
Learned advocate for the plaintiff and learned advocate for defendant number 5. Defendant number 6 is not represented.
Today, otherwise is represented.
Defendant number 5 are present. None appears for the defendant number 1, 2, 4 and defendant number 6. However, in the interest of justice, learned advocate for the plaintiff is requested to serve one more notice upon the defendant number 1 to 4 and defendant number 6.
T6 not required. I'll serve. Yes, I'll serve.
And they are learned advocate.
Yes.
Let this matter appear on. Shall I keep it on the reopening date?
Please, no. One day after the reopening.
Let this matter appear on 27/10/2025.
27th.
27 Milord, some difficulty.
I was trying to expedite the suit.
Okay. 29/10/2025. Under the same heading.
Lord, one request from your lordship. Kindly mention that I will mention it that if they don't appear,
okay,
the suit will proceed undefended against
made clear that no further opportunity will be granted on the next date to the non-appearing parties.
Great. And the suit will proceed undefended.
And necessary orders will be passed.
Very well. Grateful.
Deeply obliged.
Item number 17.
We are for the plaintiff. This is for the issues to be framed, my lord, my lord. I'm carrying the issues, my lord. Last occasion, I took an adjourn.
Application, Lordship directed us to serve a copy of the written statement.
That has been done. I have gone through the written statement also. So this is my the issues on behalf of the plaintiff. Brief ta daw na.
Yes.
I'll tell you the.
What is the suit for?
The suit for declaration and permanent injunction. Now, if lordships, oh my God, plain tag paper. Plain tag paper. হ্যাঁ দাও না নিশ্চয়ই না তোমারটা দাও ও প্লিজ I got it madam sorry এটা দিচ্ছি sorry দুটো প্রিয় আলাদা হয়ে গিয়ে she will see the plaint once I just tell you the plaint tag দাও জজকে from the cost title I just indicate is not we made it a big huge from 2006 I was going through the plain written statement
so from 2006 we have now come to the framing
issues there have been 7-8 general applications, still 1 or 2 pending. So when I came in, I said, suit can't be remain like this for 20 years. Issues framing. Be that. It's better one day we start.
Yes.
Now the plaintiffs. Plaintiff.
You have a copy. Give me a copy. Extra copy if you have.
GA16 ta dao Joseph. GA16 annexed ache. Yes. The plaint is annexed at 110 of GA16. Plaint is annexed at 110 of GA16. Now, Lordship will see the plaintiffs before Lordship and the 3 plaintiffs, Orunada, Usha, Manjula. They are the legal heirs of one Brij Gopal Gupta. Now, the defendant, number 1, Alka Gupta, is the daughter-in-law. Defendant number 2 is the East India Securities, which is a DMAT agency. Defendant number 3, original was Prem Lata, who was the widow of Brij Gopal. It's mentioned, Malab. Kalpana is also the daughter of Brij Gopal. Now, after looking into, and last is Ashok, who is the son of Brij Gopal. So it is basically a dispute between the heirs of Brij Gopal with the daughter-in-law. Daughter-in-law is Alka Gupta, the defendant number 1. Now, during the lifetime of Brij Gopal used to hold shares in a DMAT account in East India Securities, which is defendant number 2. The shares, the DMAT account was jointly held by Brij Gopal and Alka Gupta, who is the defendant number 1. And he continued to hold the shares jointly with Alka. On the death of Brij Gopal, we are the heirs of Brij Gopal. On the death of Brij Gopal, Prem Lata, the widow, he filed a succession certificate. He was a city civil. Prem Lata is the widow.
Prem Lata is a party, not a party here.
Died. Subsequently expired.
Yes, yes. And substituted also.
Heirs were already on record, so only the death recording was required.
Yes.
The heirs were already on record.
Prem Lata Gupta.
Prem Lata, yes, it's the Prem Gupta. What a Prem Lata Gupta, yes. So Prem Lata Gupta applied before the city civil court at Calcutta for grant of a succession certificate in the goods of her husband, Brij Gopal, which was granted in her favor. So the properties of Brij Gopal under succession certificate came down to the legal heirs. Now, in the meantime, what happened? Alka Gupta, the daughter-in-law, he started dealing with the shares. Now, if Lordship see the plaint after this, paragraph 6 of the plaint, the daughter-in-law, taking advantage of the joint holding in the DMAT account, has taken out all the shares representing to be the owner. He can be a customer.
Your main allegations is against which defendant?
1.
Defendant number 1.
Alka Gupta.
Yes.
I had the others are pro forma. Others are pro forma.
Okay, so your main allegation is against defendant number 1.
1.
And what is their defense to
Yes.
your allegation?
And I say defendant number 2, 1 and 2 have acted in connivance. Now, Lordship, I'll just come. Lordship will kindly come to the prayer portion. My prayers will make it clear. My relief sought for A, page 14 of the plain text to বের করে রাখো। আচ্ছা page তো
Yes, page 14.
amended ঠিক আছে দিয়েছি ঠিক আছে হ্যাঁ ঠিক আছে A, decree for declaration that Alka Gupta, the defendant number 1, was and is holding the shares in the schedule as trustee for the benefit of the legal heirs of Brij Gopal. So she being the second holder, she was only holding as a second holder for the operative convenience.
The question is, on the one hand, that Prem Lata Gupta obtained a succession certificate.
Yes.
How much share was?
No, she died entire because she was a widow.
No, Prem Lata, you see, the original holder of these shares, after his death, Prem Lata Gupta, the widow, obtained succession certificate.
Yes, in her name.
And by virtue of the succession certificate, how much?
All the heirs got equally.
All the heirs got
all
equally.
The heirs got equally. The four daughters and one son, along with the mother. Once the mother is no more, it's only the daughters and son.
So it was a joint holding of the daughter-in-law and the
father-in-law. Yes.
So after the death of the father-in-law, it vested by way of succession upon his father-in-law's portion upon the widow and
yes,
his daughters and sons.
Obliged, man.
So that is done.
Yes, but the daughter-in-law dealt with the shares. Daughter-in-law Alka Gupta, she dealt with the shares. Entire. A minuscule portion left. That is the case.
Plaintiff's case.
That's the plaintiff's case.
That in spite of the succession certificate, the daughter-in-law.
Succession came a bit later because she started dealing with immediately thereafter because it will take some time. Succession came a bit later. Even if without a succession, a daughter-in-law is not a legal heir. Even when the son and daughters are present.
Yes.
So she being a daughter-in-law, she dealt with the shares. That's my case, that you are holding in trust or as a beneficiary. The defense case by the Alka Gupta's written statement is that, she is the absolute owner. So that has to be decided. কোথায় এই রে তো এটা কোথাও দিল এক্ষুনি মেপি সাপ্রেশন ঠিক আছে এটা তুমি বলবেই actual cause of action, very good.
So what jurisdiction you mean to say? This territorial jurisdiction or inherent jurisdiction? This maintainable?
Well, I'll tell you, Lordship. The jurisdiction issue is generally we put because this is the limitation, maintainability, jurisdiction. I think these are limitation has to be under the Limitation Act. The others are in general that we put, but I didn't find that. Because in the written statement, they have taken a point of a section 10 proceeding of. So I think they have covered in the issues. So first three are, though not taken, I have written that can be, limitation has to be there in any framing of issues. They have also said maintainable. Grant of succession certificate. Sufficient title, yes, that has to be. But my learned friends, issue 8, I believe, is the main issue.
Yes.
Issue 8 of my learned friend is the main issue. That's the main defense. And 9 also. Yes, 9 also. It are pending. Issue. What I inquired.
What is this title suit pending before the city civil court?
That's the case in written statement that is pending. But I inquired from my advocate on record. It is nobody proceeded and it got dismissed. Or
what was the subject matter of that suit?
That in the written statement the defendant has taken that it's identical to this suit. Identical to in the written statement they have taken. Lordship can put this issue can be decided.
Yes,
it can be decided.
Yes, anything you have to say
can be decided.
Lordship, I'm being led by Mr. Shumandar in this matter. Lordship may frame the issues and we'll come back with
Yes, record an order.
Frame the issues.
Learned advocate for the plaintiff and learned advocate for the defendant are present.
1500.
Are learned advocates for the parties. Both the learned advocates have filed suggested issues. Upon perusing the suggested issues submitted by the learned advocates for the parties, and upon hearing the learned advocates, this court is of the view that the following issues should be framed. Number one, is the suit as framed maintainable in law? Number two, whether this honorable court has jurisdiction to try and decide the instant suit.
It can be given to the officer.
Whether the relief's claim is barred by limitation. 3. Whether the defendant number 1 as joint holder with late Brij Gopal Gupta of the demat account number client ID 1011.
Lordship, they can copy it from that, otherwise.
But some has to be deleted, not entire thing. Acha, the following issues should be framed. Acha.
Anything.
Yeah,
because I've made the issues that become a bit bigger.
1, 2, 3. ঠিক আছে? 4, 5 of the issues suggested by the plaintiffs. আমি বলে দিচ্ছি কোথায়।
And my learned friends issues, I think.
তারপর item 6 করুন।
হ্যাঁ, এই কটা রেখে দিলেই তো পারে। হ্যাঁ, তোমার 8, 9, 10 রাখতে।
Item 8
ইম্পর্টেন্ট রেখে দাও। 7, 8, 9 হ্যাঁ, ডান। সেটা রাখবেই তো।
Item
এই তিনটে রাখি।
10
তিনটে চারটে রেখে দাও।
Item 12 মানে যেটা বললাম সেটা, হ্যাঁ, যে এবারে পরে চলে আসবেন ইস্যু সাজেস্টেড বাই দ্য অন বিহাফ অফ দ্য ডিফেন্ডেন্ট থেকে আমি যত ওখানে যেটা লাস্ট হচ্ছে তারপরে সিরিয়াল নাম্বার দিয়ে দেবেন, ঠিক আছে? হ্যাঁ, ওটাকে সিরিয়াল নাম্বারটা ওইভাবে আসবে আর কি। Item 7, Item 8, Item 9, Item 10.
Lordship has taken my 12th issue. So that's the, I rope in defendant number 2 by that.
ওখানে Item 12 of the plaintiff এর কথাটা দেওয়া আছে, Item 12.
Well, we'll kind.
12 আছে.
Oblige.
Just 1 or 2 minor issues.
Maybe a repetition also. Maybe a repetition also.
Yes. Let this matter appear.
There are 3 general applications which are pending.
Okay, after vacation.
Yes. All the pleadings.
No, let this matter appear on 3/11/2025.
3, yes. No, 4th. Not on 3rd. 4th.
4/11/2025. Under the heading.
Adjourn motion. Because those will be adjourn motion. The applications.
Okay.
Adjourn motion.
Okay, adjourn motion.
It's interim order chilo. There was a sir, thank you. There was an interim order which I was enjoying.
Interim order passed earlier stands extended for a period of 4 weeks after vacation or till further orders, whichever is earlier. Now the suit has to be heard out.
That has to be heard. I think inspection discovery has been done. Judge's brief. Judge's brief filed.
No, affidavit of documents after the issues.
Judge's brief. My witness will be in the box.
No, affidavit of documents have been filed. Affidavit of documents.
Yes, those has been filed. Judge's brief dekho na. Hey, dekho na.
So discovery and inspection is complete.
Yes. Judge's brief
has been filed.
I will take care.
Okay, let it appear. There is necessary inspection.
নেই তো দেখছি হ্যাঁ জাজেস ব্রিফ আছে we will look into it. কোঅর্ডিনেট করে সবসময় কোঅর্ডিনেট করে নাও যা নেই অবলাইজ
Claim 18. Hello, this is my suit for recovery of possession. The
GS6.
inspection and discovery complete.
GS6, whose application?
No application is pending.
Why this application is appearing? J6?
There's no, according to me, there's no application pending.
Now, my for
Framing of issues, my lord, today I have not been able to come ready. Kindly keep it after vacation. I'll come with the issues.
Yes, record and order. Learned advocates for the parties are present. Today is fixed for framing of issues. Learned advocates pray for time to file the suggested issues. Let this matter appear on the reopening date.
On the 3rd of November.
Let this matter appear on
1 week after.
3/11/2025 under the same heading.
Grateful, man. Grateful.
Number 19. Please, my lord, I appear for the plaintiff number 3. My lord, today's fix for framing of issues. My lord, I have come up with my suggested issues. My lord.
So it is appearing under the undefended suit.
My lord, two defendant numbers, only defendant numbers 2 to 7. Your lordship was pleased to pass an order placing them undefended. My lord, defendant number 1 has filed its written statement but is not appearing despite multiple.
Okay, let the
petitions.
issues be framed.
Yes, my lord.
Yes,
My lord,
give me.
may I hand over the suggested issues, my lord?
So have you intimated the defendant number 1?
Yes, my lord, multiple times, my lord.
No, on the last occasion?
Yes, my lord. May I hand over the affidavit of service, my lord?
Yes, record and order. Learned advocate for the plaintiff number 3 is present. None appears for the defendant number 1 in spite of service of notice. The plaintiff number 3, learned advocate for the plaintiff number 3 has filed the suggested issues. Stop. Upon considering the suggested issues and upon hearing the learned advocates, the following issues be framed. Yes, 1, 2, 3, 4, 5, and 6. Quote from the suggested issues filed on behalf of the plaintiff 1 to 6.
Lord, suit for declaration and partition.
Yes, let this matter. So, affidavit of documents filed.
No, my lord. Lord, no documents have been filed by us. Judges will
Let
file
this matter appear on 28.
Lord, will it be your lordship's pleasure to keep it 1 week or 2 weeks after vacation? In the meantime, I'll take steps to file the documents, my lord.
No, I'm keeping it after the reopening as to be mentioned. On that date you file.
Okay, grateful.
Let this matter appear on 27
Lord,
10.
week, Lord, 1 week after the reopening.
Okay, 6/11/2025. Under the heading to be mentioned, the affidavit of documents be filed by the plaintiff, by the parties on the said date. Both the parties plaintiff.
Lord, I don't think they will appear or file any document.
Learned advocate for the plaintiff is requested to intimate learned advocate for the defendant number 1 about the next date fixed.
Grateful. Yeah. Number 20.
The plaintiff laid by Mr. Amitabh Mukherjee.
I refer to the last order dated by August 27, 2025.
GA9 is for what?
No, the GA9 has been disposed of. GA9 has been disposed of because my application was kindly disposed of. My application was for amendment of the written statement.
Yes.
And that was allowed on contest.
Yes.
This is the last order kindly. I love that the second paragraph, my lord, as learned advocate for the defendant number 3, that is me, my lord, has filed some additional suggested issues which are being taken up for consideration. These additional issues are being considered and framed. Let these additional issues be treated as a part of the original issues which were framed on 10 December 2024. My lord, 10 December 2024, that the original issue was filed. This is the matter.
Okay.
So I seek for an order, my lord, that let it be incorporated in an order. Otherwise, my lord.
No additional issues, acha, be treated as the part of the original issues which are framed.
Yes. And so let all issues be incorporated in one order.
So that is there.
My lord, first issues that is on 10th December 2024,
No,
it was passed.
yes, 10th December.
Kindly see then the earlier issues suggested.
And give the present suggested issues.
My lord, yes. And presently the suggestions I have filed, man.
Okay.
Even
Yes, record an order.
my lord. So all should come
Learned
in order.
advocates for the parties are present in terms of the order dated August 27, 2025. It was directed that the additional issues suggested by the defendant number 3 should be part of the original issues which were framed on 10th December 2024. Upon considering the issues which were framed by order dated 10th December 2024 and the additional suggested issues, the following issues are framed. এবার এখান থেকে 1 থেকে 6. Yes, do you have a copy of the additional suggested issues?
My lord.
এখান থেকে এটা 6টা দেবেন প্লাস ওই যেটা দিচ্ছে ওটার সাথে।
Yes, my lord, I have got it.
না ওটা তো আমি যা বলার বললাম। এবার following issues are framed হলে এই করবেন।
I have filed in the court, my lord, also on the
just a minute. পরে তারপরে এই যে এখানে 6 আসলো তো তারপরে এখানে চলে যাবে। এই এখান থেকে 7, 8, 9, 10, 11, 12 হ্যাঁ ওখানে 7 হয়ে যাবে ওয়ানটা করে কন্টিনিউ হবে সিরিয়াল নাম্বার দিয়ে এখানে শেষ। No, regarding this 7, okay.
Hello.
7, you see 7 cannot be incorporated because your prayer for amendment with regard to 7 was dismissed. Except 7, except.
It was not dismissed.
No, you're at the time of considering your application for amendment.
That is the contingent part.
No, question is.
Not this matter.
No, Amarnath Mehta.
No, my lord, Amarnath Mehta, that was gone into, my lord. But the contingent, I have taken the law point.
No, probably. No, you have taken a point regarding service of notice. In your amendment application,
yes.
You have taken without service of notice.
No, I have not taken that. I have stated that Amarnath Mehta is the part of the agreement, my lord.
Yes.
So, but Amarnath Mehta not included, not implemented as a party of that.
The question, your prayer for bringing Amarnath Mehta.
Yes.
As a party.
As a misjoinder, not my prayer.
No.
Not my prayer.
Because you see, specifically it was refused. Anyway, let it not be incorporated now. Subsequently, if you can show, I can incorporate it. Acha, 7টা বাদ দিয়ে বাদ বাকিগুলো।
My lord, is not Amarnath Mehta the necessary party in the because in the circle as treated.
Anyway, I am not including
15D,
him.
My lord, 15G are allowed. Only 15D not allowed. My lord, kindly refer to the last order.
You have the copy of that application.
That is due to lordship's order, my lord. On 20th May.
Anyway, you see, issues can be recast at any point of time. If you can show me that it was there, it was allowed, I'll incorporate that.
My lord, it is a glaring fact that on 20th May, your lordship was passed that order, my lord.
No,
and
15D. Probably one of the prayer for your amendment.
Kindly, one moment. 15D takes that. That 15D, my lord, that was disallowed.
Your prayer, but probably you had prayed that this person be brought.
No, that was allowed, my lord.
No, definitely not. Only that was the prayer which was rejected. Rest everything was allowed.
No.
Anyway, I'm just making it. If you can show me, I'll recast the issues. Sevenটা বাদ দিয়ে বাদ বাকিগুলো। আচ্ছা, let this matter appear on. I'm keeping it after vacation.
My lord, discovery and inspection has been done.
My lord,
it is done.
Discovery inspection done, my lord. Let them ask to file the judge's brief.
Yes, lordship.
Let this matter appear on 4/11/2025
My lord, not after 8/11, my lord, because I will not.
Okay. On 10/11/2025, the judge's brief of document be filed on the said date.
On that, and service in the meantime.
And service in the meantime.
My lord, that kindly keep it open on that date, my lord. I will
See, at the time of argument also issues can be recast.
My lord, that scope be given, my lord.
It is not necessary. At any point of time you argue, make a prayer, I shall consider. But you have to show me that I have not rejected that.
That is, my lord, I definitely, my lord,
Yes.
because 15D, that was not allowed.
I shall
But
see.
15G was allowed.
Very well, if it is there, I
That
shall.
was the last prayer of.
If it is there, I shall.
Because
Definitely, I will recast it.
15G already included in the register, amended register. I have not come with the copy. If you not
Come on that day.
tomorrow, my lord, I will show you.
No, come on that day. If you can satisfy me, definitely I will recast the issue.
My lord, kindly recover it also. Remember that. I am obliged. My lord, may I get back the order, my lord?
না না এই হিসেবে এগুলো ঠিক আছে ওই যে পরের যেটা হ্যাঁ এটা ওইখানের ওইটা ওই 7টা বাদ দেবেন আর কি
For the time being, my lord, I will satisfy you lordship on the next day. Because that was allowed.
Issues can be recast at any point of time.
But still, my lord, that is very important because he is not made party purposely.
Yes, whether if I have rejected your prayer on that ground in the amendment application, I cannot entertain it again.
Amendment application that was already government, my lord. That is your
Very well.
To allow that.
If there is no such observation, I shall include that.
My lord, my lord. My lord,
Yes.
May I get back the order?
Yes, take back. If possible, give a Xerox copy.
Order dated ta koto? 10 December 22. My lord. 10 December.
Yes, call the fixed matter.
Okay. Number 21.
Call the fixed matter.
43. Made please, your lordship, my lord.
43. Yes, today you have to reply.
Yes, my lord. Today replied. I would like to complete, my lord.
All other matters of the future lordship be releasing the recess.
Yes, other matters are released till recess.
If your lordship would be pleased to come, my lord, once to the recalling application, volume 2. My lord, the document that I was placing last in volume 2, yes, page 209. A second, Bakun. My lord, in answer to your lordship's query as to how, my lord, this fraud has been committed on my client and that how misrepresentation has been made before this honorable court in getting the order dated 2nd of May 2025, I was placing, my lord, the letter that has been written by my present advocate on record to all the partners of the partnership firm, which appears at page 209, my lord, of this particular document. Your lordship will be pleased to recall, my lord, only 2 dates. This is the letter of 28th of April 2025, and the order that has been pleased to pass by my lord, which I am seeking recalling of, is passed on the 2nd of May 2025. My lord, I had demonstrated before my lord till up to item number 8, Sharup Mukherjee, who has also received. My lord, most of the partners have received this letter in which the present advocate on record.
Two aspects: service upon the partners, service upon the power of attorney holder, and service upon the former learned advocate.
Yes,
these are the 3 services.
Yes. My lord, this letter, which I was placing on the last occasion, which I would like to complete today, is, my lord, service upon all the partners. My lord, here there are 2 aspects: service upon all the partners and also on the power of attorney holder. The power of attorney holder is, my lord, item number 9, Shom Shankar Mukherjee. I'll come to him. There has been a lot of
argument on behalf of the power of attorney holder that he has not been served. But with regard to the majority of the partners, my lord, may I demonstrate up to 8 Swarup Mukherjee, my lord, he has received, which will appear from page 234. I have been, my lord, indicating all the pages as to from where it will appear that which partners have received and which partners have not received. Item number 8, my lord, 234. Corresponding, my lord, I have been showing all the documents. If your lordship kindly comes to 234, item delivered on the 1st of May 2025 at 4:56. Then, my lord, Som Shankar is the power of attorney holder. I'll deal with him subsequently. May I come to item number 10, that is Sonali Roy. Oh, my lord, I stand corrected, my lord. 234, my lord. Yes, item delivered to sender, my lord, he has not been served. I stand corrected. My learned junior indicated item delivered within bracket, it's written sender. So it's come back. It's come back.
That is Swarup Mukherjee.
Yes, my lord, Swarup Mukherjee. My lord, then your lordship will skip Som Shankar Mukherjee for the moment. I'll deal with him. Then, my lord, Sonali Roy. Sonali Roy, my lord, 236. And Sonali Roy, by that time, my lord, was the majority shareholder. And, my lord, the power of attorney holder by that time was not a partner anymore. However, 236, if your lordship kindly comes, Sonali Roy has been delivered, item delivered within bracket addressee. And this is done at 3:30 on the 1st of May 2025. Shamraggini Royta kon patay hobe? Shamraggini Roy 237 mona hai.
This is done 1st of May.
240. Yes, my lord, 1st of May.
Time?
3:30, my lord.
3:30.
Yes.
And probably the date of the order is 1st May.
2nd May.
2nd May.
2nd May. না 38 হ্যাঁ রাজেশ্বরী তার আগে আমি একটা একটা করে দেখতে ওই সম্রাঙ্গিনীটা কি 230 240 একটা একটা করে দেখাচ্ছি so my lord and your lordship will kindly see the addresses, they are all within Calcutta. A telephone call, my lord, would intimate as to what's going on. They're all within Calcutta. It's not that they're far off. There would be a lot of time involved in coming and intimating. Then, my lord, your lordship will come to 11. I've shown up to 10, then 11. One by one, I'll take your lordship to Then, my lord, 11 would appear at page 240.
Yes. This is 237.
Yes, my lord.
That is item delivered to the sender.
Yes, my lord. 237 is Som Shankar. He's a power of attorney holder. Yes.
Power of attorney holder.
Yes, my lord. I'll deal with it. My lord, the address your lordship will kindly notice.
Cannot be located.
Cannot be located. This address is the address, my lord, your lordship will kindly see the address. Yes. The address is 178 by A, Raja Dinendra Street. This is the address, my lord, Som Shankar himself used in his affidavit in opposition to the present petition as late as in 2025.
Anyway, if address cannot be located, it is not the fault of the addressee or sender, it is the fault of the postal authorities.
My lord, the thing is, if your lordship will kindly visualize the thing. There have been 2 addresses given of Som Shankar in this proceeding.
Yes.
One of Olai Chandi Road. There, my lord, the previous advocate on record had addressed at Olai Chandi Road with regard to our having intimated. And the present advocate on record has also addressed Shom Shankar at this 178A Raja Dinendra Street, which is the address he himself has used in his affidavit in opposition to the present petition in 2025. My lord, it has come back, item delivered to the sender. Be that as it may, with regard to the other partners, my lord, your lordship will kindly see whether the majority of the partners were intimated much prior to the passing of this order or not. The other partners, my lord, also have certain duty. It's not that they're going to keep their eyes closed. And by that time, Shom Shankar was not a partner. The majority partner was Sonali Roy, 10, item number 10. She has received it, and she received it at 3:30, 1st May, and the order was passed on the 2nd of May.
So far this Swarup Mukherjee is concerned, it is not delivered. Sonali Rai is concerned, it is delivered.
Yes. I'll tell my lord who all are delivered.
Yes.
Item 1 received. Item 1 is Chatterjee
Yes,
seal. They have received.
237.
Item 1, my lord. First item, first person. Chatterjee seal. They have received the previous advocate on record. Then Probate Roy has received. Jhumpa Chakraborty received.
That is page 238.
Jhumpa Chakraborty.
Yes.
Jhumpa 221. My lord, Jhumpa Chakraborty is at page 221. Jhumpa Chakraborty is 221, my lord. I didn't deliver that. Jhumpa Chakraborty is 221. At the top it's Jhumpa Chakraborty. আমাদের নিজের item A করে দিয়েছি. And she has also received on the 1st of May at 5:05. Sri Bhumi, very much within Calcutta, VIP Road. I'll take your lordship one by one. They are all partners. It's not that they are not partners. They're not outsiders. Then, my lord, your lordship will kindly come to 6. Prosun Roy, page 224. Item delivered on 30th of April at 3:08 1.5 days left before passing of the order.
That is 225.
224, my lord. Prosun Kumar Roy, 224.
224, yes. Okay.
Then your lordship will kindly come to Konika Sheth. Most of them have been delivered, and delivered at least 1 day in advance. Most of them, and they are all within Calcutta. Then Konika Sheth is page 218, my lord. 218, a little bit here and there, paginations. 218 on 30th of April. Again in the afternoon.
Yes, this is so far with regard to the partners, power of attorney holder, and the former advocate.
Yes, my lord, there are 2 more.
Yes, two
There
more.
are
Yes,
2 more, my lord. 11, 12, and 13. 3 more, in fact.
that is page
11 is page 240. Item number 11 is at page 240, my lord. Item delivered to the addressee 1st of May
page
at
240.
240. Ki Shamragni Roy.
Samragni Dhar.
Roy, yes, ma'am.
Roy.
Yes. Also very much within the jurisdiction or very much near to this High Court, Masjid Bari Street, Calcutta 6. All.
No, this is what? This Shamragni 240, that is Bidin Street. No, this is Bidin Street.
Yes. Post of all, the address is at Masjid Bari Street. The post office is Business Street. Item has been delivered on 1st of May at 3:30. Some of them got on the 30th of April, some got on 1st May, latest by 3:30. So the question of communicating, my lord, cannot and does not arise. They're all within 5 to 6 kilometers of this High Court area where the office of Chatterjee Seal was there. It's not that they could not, they had to travel far distance or that there was no availability of any communicative machine. One single phone, my lord, would say, and there are so many people who have received this. Then also Rajeshwari Roy, page 238. She has also received on 1st of May. We should do my lord, your lordship will kindly weigh the probability. It's not that only one person has been served and the others have not received, so is not been able to communicate. So many of them have received and well in advance. Vaishajya Roy is 238. Oh, Rajeshwari Roy is 238 and Vaishajya 239. Latest at 3:30. Latest.
So this is all with regard to the service
of the partners.
Regarding the service of the notice of the meeting upon you, that is admitted to be served,
no,
to be received.
With
Notice of the
respect, my
meeting.
lord, with respect, I had started my submission in reply by placing.
No, now you're just clarifying.
Yes, yes, yes. My lord, there, my lord, I have submitted a written notes.
Yes.
There, my lord, there is a column with regard to all the notices which have been held according to them on which particular date, and that most of them have not been served upon me. The ones which have been served as to why I have not attended have also reasons have also been given. If your lordship would be pleased just to see that written notes once, I had placed that at the very first, at the opening of my reply. Your lordship will kindly see the written notes. They have tabulated it in a tabular form with regard to the notice.
Yes, meeting dated 36/2023.
Yes, in a tabular form, my lord, I have stated.
Page 16.
Yes.
Page 16.
With
yes.
all dates. I've given it with all dates and what has happened with regard to each and every notice. Not served upon the petitioner, not served upon the petitioner, not served upon the petitioner, not served for, not served upon the
This is
petitioner.
2023.
Yes.
And the decision to withdraw the suit was taken in 2025.
24. 24 after 1 year, my lord. After 1 year, they have withdrawn.
No,
So-
this is the meeting. So according to you, what is available in the record, you replied that there is no agenda in the meeting.
Right.
That was your reply.
Yes, my lord.
Now, this is 2023.
Yes.
The decision to withdraw the suit, when it was taken?
2024.
20?
Page 18, if your lordship kindly comes. Last one.
Yes.
Last item, my lord. 1st of February 2024.
Okay.
This is the date. And my lord, one more thing, if I should bring it to your lordship's notice is, your lordship has seen from the letter that I have just placed, my lord, wherefrom I was showing as to who has received and who has not. The first person, the first item is Messrs. Chatterjee Seal and Company.
Yes, is that you have submitted?
Yes, my lord, and your lordship will be pleased to see your lordship's order. Your lordship has been in their presence. It is written
Yes, Mr. Chatterjee, former advocate. Yes, that is there.
So they had by this time had received, they have also not brought it to your lordship's notice with regard to the specific case which has been made out by the my present advocate on record appearing at page 210. Your lordship will kindly see the specific case that has been made out. A very short letter.
Page
210 of the volume 2, the one that I was showing.
Yes. This is by your advocate.
Yes, my lord. My present advocate.
Yes.
My present advocate. Your lordship will kindly see the contents.
Yes.
Please note that I, the undersigned, have filed wakalatnama on behalf of my above-named client in the subject proceeding. Henceforth, he will be represented by me in the subject suit, and all the steps for and on his behalf will be taken by me, as instructed and in accordance with law. As such, you are hereby requested not to take any step in the subject suit for and on behalf of my above-named client, that is plaintiff number 10, anymore. You are also requested not to take any step for withdrawal of the suit inasmuch as my above-named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. Received by the erstwhile advocate on record, received by majority of the partners, but not brought to my lord's notice.
So far this communication is concerned, it was no question of any receipt because it was by mail.
No.
This is by mail. You see page 208.
My lord, I was showing my lord 210.
No, 208, that is?
That is by mail. That is by mail. My lord, 210 is the one which specifically I was showing, which have been received and which have not been received. 210.
210. Yes.
I have learned, my lord, in reply only the judgment.
No, these documents have to be produced. Which documents?
Every document my lord does.
If my lord wants clarification, can I say I will not?
I am putting some questions. Which documents were received and which were sent by mail?
My lord, 208 was sent by mail. 208 was sent by mail.
Lord, I am for the defending now, but Lord, it seems that the partners.
It is only, these are all matters on record. Let me see the documents. No question of a.
Your lordship on whatever facts he has stated today.
Yes, if my lord wants clarification.
No.
Slightly becoming
yes.
a bit difficult for me to understand. Because it seems that now the firm and the partners.
No. I am not permitting him to take any other new points. Only the documents.
Whatever is my lord, what is
the new point? I will address your lordship on.
No question of any further new points.
Your lordship is seeking clarification
on the documents.
I'm just trying to assist your lordship. My lord, 210, my lord, is the letter which they have all received.
Yes. 210. You have submitted the received by the partners and received by the former advocate. So
this was not brought to my lord's notice.
Very well. You have clarified that.
Yes, my lord, that is the sum and substance. Now, my lord, may I take your lordship? Your lordship's last query was on the last occasion with regard to the terms of settlement that one particular partner has passed away. In spite thereof, the power of attorney holder had represented him. I had to part of it. Terms of settlement.
Yes.
Affidavit in reply. What's it? Terms of settlement. Page 5. What the power of attorney holder has done is written.
Yes, written everybody's name, including your client's name.
And by the pen of Somshankar.
Yes.
What I want to indicate to your lordship is that this Pinaki Roy by that time had passed away. We have got the death certificate. If your lordship.
Yes, that's what I put. I put on the last.
May I just?
So is it on record? This death certificate?
My lord, I'm filing.
The FIR again, that reply stage is.
My lord was.
No. This is a supplementary affidavit.
Yes. Here, my
also.
My lord was pleased to inquire. My lord,
Why
if your
do you
lordship,
not serve the supplementary affidavit?
I have not, my lord, I have got it. My lord,
Like say one document will be given.
Oh, this supplementary affidavit is already matter of record, but it ought to have been served.
my lord, your lordship.
It's on record by your lordship today.
It is being filed.
And it is, they have not.
It's just being handed up as if matter of course.
This is a very
In
sharp
reply,
practice.
Your lordship was pleased to.
Extremely sharp practice from Mr. Ghosh's side.
Okay, serve,
Let him finish. Let him finish.
okay, serve a copy, please.
Let him finish. My lord, after they finish.
He cannot
After they finish.
document.
After they
the
finish.
entire
Oh, please.
He himself has written a letter to Pinaki Roy.
No.
Yes,
Question.
I'll show you, lordship.
Question.
He has written a letter to Pinaki Roy.
First of all, serve the copy.
Mr. Ghosh's client
If
writes a letter to Pinaki Roy.
after he finishes, we can't go together.
Says Pinaki Roy is dead. He then did not disclose. What kind of sharp practice is this?
No, I shall go through the record. Okay.
My lord, of this application.
Not only that, my lord, why will your lordship allow a new document which case is also not run in his application?
Kindly sees his application. Page
At the end of the
222.
document, at the end of the hearing, in reply,
Let the shouting finish, my lord. Then I'll submit. Let the
It's
shouting
sharp
finish.
practice which is not accepted
it's about
from a senior
frustration.
advocate.
Let the shouting finish first.
It's not about shouting, Mr. Ghosh.
It is very much about shouting.
It's not about shouting. It's about
Then
the
you
sharp
can,
practice that is adopted.
then you can lower your voice.
Very well. You
You're not hard
continue.
of hearing. None of us, I'm sure.
May not be the case, but I'm a
Very well. Conclude. You conclude.
You will be appalled in many other
may I
things.
ask
Yes.
may I ask
Of
a
course
question
I will be.
myself?
You
Has-
take money, you cheat people, and then you come up and show as if you're a very nice person.
Has this application been, has this ground of
It's gone out of his
Pinaki
head.
dead
No.
taken in his application?
These small giggles.
This is supplementary affidavit.
Question is, a person coming to your lordship has to make out this case in the petition. This case of Pinaki Rai being dead is not there in the petition. We have not dealt with it in the opposition naturally.
28th April
In reply,
2025,
It is
you
a
write
public.
You want to deal with it? I can adjourn it till vacation if you want.
I will finish it today. I will finish it
Kindly
today.
do not take
It
this
is,
document
your
from
lordship will
record.
not. Your lordship will not. Your
Very
lordship. May I? After they finish, my lord, your lordship will come to.
My lord, I am making a very fundamental.
So if you don't want to conclude, I can adjourn it after
I
vacation.
would like to conclude, my lord. I would like to conclude, my lord, today. This interruption is on purpose.
Kindly do not take it that way.
This interruption is on purpose.
sure that a settlement doesn't go.
Of course, yes. The
Because
illegal
he's a
settlement.
fraudster.
The illegal settlement.
He's a fraudster.
Kindly appreciate one thing. My lord, a person comes before your lordship, files an application. 10 grounds are given in the application. My lord, on that basis, respondents file affidavits countering those allegations, and hearing takes place. The ground that Pinaki Roy is dead is not taken in that application, not argued in that application. Naturally, either me or Mr. Ghosh do not have a chance to reply. Now, in reply, he all of a sudden brings out this document from his pocket without.
From my pocket. It is the
without-
death certificate from my pocket.
Yes.
I have issued it. I have issued it.
The dead man you were writing to.
He has-
Your lordship will kindly.
Can-
How many of you will be
Would
making
your
submissions?
lordship
Right?
allow? Would your lordship allow a document which is not part of his pleadings? He has to make out a case. If any document.
Your
is
lordship will
produced,
not consider. I will
the
finish
case.
my argument today.
Kindly do
My
not
lord,
take that supplementary.
Your
affidavit on
lordship,
record.
your lordship will give it back to me.
Yes.
I will not. It is only that your lordship will kindly observe the date, 21st of March, 2022. I'll take back.
And lordship
I'll
also
take back.
observe
I'll
the
take
letter
back.
at page 209
Yes,
of his application. Kindly have a look at it.
That was also been sent to a dead person.
Now question is it returned as because that person was dead?
Yes, that person is dead. They have.
No. Where is that letter?
I'll
Just a minute.
Kindly gives back that supplementary.
Yes,
We have
I'll
no
take
copies.
back. I will
We
take
have
back.
no copies.
I will take back.
Now the
This
question is
document-
The
which document that is the letter has returned, that it was, you have served the letter page 209
Yes, my
and
lord.
that has returned. Yes?
Your lordship.
222.
Let me see. 222. Yes, page.
222.
Item delivered, sender.
Lordship will kindly note.
No, what is the item delivered? So that means.
Sender.
Yes, sender, definitely. So what was the ground? Oh, item return deceased.
Yes, item 223.
So he knew
But he chose not to bring it as a ground, not to file an affidavit affirming this ground in his application.
Very well. There is no scope to rely on his
Yes,
I will
supplementary
not.
affidavit.
I'll take it back.
Very well, very well, very well.
My advocate on record has made a mistake not to serve on them.
No, no.
I will take it back. I'm taking it back. I'm taking it back.
Okay.
A deliberate ploy of only trying to procrastinate this matter, which I will not.
Yes,
which
please
I will
proceed.
not.
Please proceed. Other grounds.
Yes, my lord. With regard to the factual thing, if there is any other clarification that your lordship would be pleased to answer,
Regarding
my
service
answer.
of the documents, regarding service of the notice of the meeting.
Yes.
Regarding service of the lawyer, these are all matters of record on which you have submitted.
My lord, with regard to the judgment that has been cited by Mr.
Because you see, after this, you have filed your short notes.
Yes.
After you conclude, both of you, all of you, we will also file.
Our short notes are ready, we'll file it today.
Yes, file short notes along with compilation list of dates. Yes, yes.
Only with regard to the judgment that Mr. Rupak Ghosh was pleased to cite, my lord, may I just distinguish that the judgment does not apply in this case. My lord, the judgment was of that of 1953 SCC online.
Document otherwise.
Yes.
I will record that it will be kept with the record, but the court cannot rely on it.
Whatever, my lord, whatever.
Whatever. I will say that copy has not been served. So
I can
court will
serve
not
the
take
copy.
cognizance of it.
Cannot be taken on record.
Without service at reply, he's filing new.
Your lordship.
This is an affirmed. This is an affirmed copy. No, definitely.
Affirm supplementary.
The Taj Mahal is fine.
Affirm supplementary doesn't mean it has to be kept on record. He says he's going to take it back.
Yes.
Taking it back.
Yes,
I'm taking it back. I'm taking it back.
Kindly gives it back.
If my lord is not considering, what will my lord record? My lord, may I continue, Mr. Ghosh?
Article 2.
May I continue?
My lord, Article 215 court. It's a court of record. If it's on record, means it's on record. Lord, will kindly return it, my lord, because otherwise, my lord, subsequently, if my lord, we go up in appeal, it will be argued court has taken it on record.
Court has taken it on record.
This is the Article 215 court. It's not so simple.
No, question is so that in future, if it is on record, it is an affirmed copy. Whatever deposition is that, he cannot detract from that.
Mean it has to be on record.
You see.
We affirm 200 supplementaries, but court only accepts.
And if today or tomorrow also, you can take a certified copy of it also.
There is no requirement.
Because if you want to take this, if you want to challenge this, you can collect a certified copy if it is on the record.
Question is, he doesn't want to rely on it. He wants to take it back. Kindly gives it back.
Yes, please.
My lord, may I distinguish the judgment?
Yes.
Placed by Mr. Rupak Ghosh, AIR 1954, Calcutta 409. My lord, factually, they are here in this particular case, all the plaintiffs had filed the suit. In that case, my lord, only the dissenting partner he had gone against the wish of the majority and had filed the suit. That is number one. Secondly, my lord, the meeting that was being attended by all the partners was not being attended by the dissenting partner. Here, factually, my lord, I've demonstrated before my lord that the notices of all the meetings were not at all served upon me, as a result of which the question of my not admitting the meeting willfully cannot and does not arise. There's another factually a different matter. Then, my lord, the dissenting partner was given all notices, still he did not attend in that particular case. And, my lord, the honorable judges from the plaint of the case also felt that there was no prospect of the success in the suit. Yes. My lord, the prospect of success in the suit on merits was not there in that particular suit. Here, my lord, my specific submission has been that if the suit is withdrawn, the partnership firm is going to be prejudiced inasmuch as the property over which the partnership firm has a tenancy right will go away and the defendants are going to be made the tenants. The defendants will be made the tenants if the suit gets withdrawn, because in the suit, the plaintiffs are wanting recovery of possession from the defendant who are in wrongful possession. And the defendants are now saying that they would be directly pursuant to the settlement, become the tenant, and the partnership firm's tenancy right would go away. So, my lord, the right of the partnership firm would go away to the prejudice of the firm. Then, my lord, your lordship will kindly see in this particular judgment, when your lordship would be pleased to go through it, there was a specific clause in the partnership agreement. My lord, that specific clause was
that is there in paragraph 16. My lord, if I may just read out paragraph 16, your lordship will kindly make a note. The specific clause in the partnership agreement in this case also expressly says that in case of any difference of opinion at any time during the continuance of the partnership firm, the opinion of the majority shall prevail. There is no such specific clause in this partnership agreement. No.
So is it in your application that partnership deed? But have you annexed in your?
Yes, yes, the partnership.
Yes, very well, very well.
Yes, yes.
Then it's okay.
It is there. It is there. And my lord, two more other points that I have. The honorable judges, before in passing of this order, had given specific importance to this specific clause, which would appear from paragraphs 24 and 27 of this judgment. They had specifically said it is because of this specific clause in the partnership deed that the majority opinion will prevail, that the dissenting partner's opinion or dissenting partner's action was not supported by this honorable court. But no such clause was there in our case. And my lord, this decision, if your lordship kindly comes, is before the 1976 amendment. If your lordship kindly comes to order 23, rule 5.
No, order 23, rule 5, you have submitted
Rule
on the
one,
last occasion.
One, my lord, rule.
Yes, which was clarified also.
Yes, yes. Yes. Your lordship kindly sees order 23, rule 1.
Yes.
The first proviso, my lord, substituted by Act 104 of 1976 with effect from 1st of February 1977.
Order 23, rule 1, yes.
My lord, that includes order 23, rule 5.
Order 23, rule 1, sub rule 5.
Yes, my lord, sub rule 5.
Yes.
Nothing in this rule shall be deemed to authorize the court to permit one of several plaintiffs to abandon a suit or part of a claim under sub rule 1 or to withdraw under sub rule 3 any suit or part of a claim without the consent of the other plaintiffs.
So this was brought by 1976.
Yes, my lord. With effect from 1st of February 1977.
Now, whether this, all the plaintiffs includes of a partnership firm or not.
This judgment is of 1954.
Oh.
So this was
this entire, you see, entire subset, that is rule 1 came into force in 1976.
Yes, ma'am.
Entire.
Yes, yes, mother. That is what it is. Right up to this, to the bracket.
Yes, entire rule
to
1.
the bracket. To the bracket.
So what was the, oh, in different states there are different amendments.
So and this is of 1955. That is what 54. That is what I wanted to bring into your lordship's notice. Only one thing, my lord. The written notes does not incorporate the judgment.
No, question is, what I have said is your written notes, list of dates and compilations. List of dates, written notes, and the compilation of the judgment. This thing, three things should be there. So whether your written notes consists of the compilation and the list of dates.
My lord, we have not placed any judgment. They have placed one.
Question is, if you want to place any judgment, both of you.
No, we have not
just
placed.
after 2 days, I'm keeping it as to be mentioned.
We don't want to place any judgments. One judgment I've cited.
That is it.
Distinguished.
That is it.
So is it enclosed in your written notes?
Yes, and already given to your lordship.
No, maybe, but
Yes, it is enclosed.
all these things should be in a compilation form. Otherwise, we lose track.
My lord, we have also given our written notes. I mean, we don't need to, everything is given. The written notes is given. We have dealt with everything.
It's ready with the judgment.
So written notes with the judgment enclosed.
Petition.
You have distinguished it.
Yes, my lord.
Yes.
We have also given our written notes. before.
Yes, that is, yes, record and order. Learned advocates for the parties are present. Learned advocates for the parties. Hearing is concluded. CAB.
Deep law. But my lord, the interim order is to be extended till
The
any further
interim
order.
order stands extended till further orders.
Deep law.
Again, at the cost of repetition.
Till further orders.
At the cost of repetition.
Yes.
My lord, that supplementary FTP.
Yes, you take it back. So I'm not recording any order.
Your lordship would not.
Hey, ye din to dekhiye.
My lord, may I permit to mention one matter, my lord?
My lord,
Pray for
Just a minute, just a minute.
My lord, apropos, since he is not relying on that, but he has made this argument that Pinaki Roy was not alive.
No, there will be no, you see, had it been record also, there would not be any reflection in the any order, that supplementary affidavit.
No, not only supplementary. I'm saying he has said that one person is dead. But this is
Whatever it is, you see, if that person is dead and it appears from the record,
then only.
then not from the supplementary affidavit.
The other aspect, one small submission. Lord, in the suit, if your lordship sees the order concerned, it's not a decree, and it's not a decree against a
So
dead
withdrawal.
person. It's a withdrawal of the suit. So, my lord, it's not as if the court is passing a decree against a dead person. That's one. The second aspect, my lord, what
That
is
was
the
not
law
the
of
submission
partners?
at all. Anyway.
Because the submission was never made. This new submission has come in reply. The second aspect is this, my lord, that if there are disputes between the partners, why should the defendant suffer?
So I'll try to protect you as far as possible.
Lordship, kindly, my lord.
Let's see.
He has taken money from me.
So whatever protection has to be given in accordance with law.
All from the bar.
So otherwise, you see, otherwise, even if the judgment is reserved, if till today, even till today, if all of you are agreeable to go for mediation, I can send today also.
And one more thing.
There cannot be any possibility. If this
My
is
lord,
the attitude, my lord,
one more thing with respect to.
my lord, interim order has been extended, my lord.
Yes.
Yes, interim order stands extended till further orders.
Only one submission apropos what Mr. Ghosh has submitted with regard to that letters being served. My lord has seen all the letters that have been served are on 1st of May at late hours. My lord, once a person has given power of attorney to another person, they don't bother. These are all mostly old senior citizens. They don't bother. And within one day, it is not possible for them to call up or to find out. And they know Malad Chatterjee Shil is there. They know that the also that the power of attorney holder himself is addressed in the letter. Why will they call up?
Anyway.
This is absolutely a non-starter. Malad, may I file my notes?
Yes. Let the written notes of arguments filed be kept by the plaintiffs and the plaintiffs and the defendants be kept with the record. No, both are separate written notes.
Separate.
You
have already filed our written notes.
Okay.
It is already there.
একটু দেখে নেবেন তো written notes গুলো argument গুলো সব তিনটে একসাথে আছে কিনা plaintiffs দুটো plaintiffs আর other defendants এগুলো একটু দেখে নেবেন আর কি
দেখুন এক্ষুনি আপনাকে যেটা দিলাম
by the plaintiffs and the defendants be kept with the record.
my lord.
Yes.
এটা একটু স্টিচ করে ফাইল করছি জাস্ট এই জাজমেন্ট
সবগুলো দেখে নেবেন সব written notes গুলো আছে কিনা. Yes.
I'm only praying for leave, my lord, to carry out amendment by order dated 1st September 2025 in GA 19.
Is it a chamber matter?
Yes, my lord.
Chamber. So mention tomorrow at the time of chamber, or it can appear as to be mentioned tomorrow. Give the slip, it will appear as to be mentioned.
Great.
And order 23, rule 1, sub rule 5 has no manner of application. Those partners have acted.
Anyway, let us see.
And lordship knows each partner is an agent of the other. That's a fundamental principle of my notes.
Yes, keep it.
Great. So grateful for patience.
Yes. Yes. Okay. Yes. Fixed matters. Yes.
Number 38.
May I please, Your Lordship?
Yes.
Item number 42.
Item.
Item number 42.
Yes. Yes.
This is the crossing
Who is appearing?
Yeah, I appreciate that this is coming very last moment, but it is not a cause that we been adopting on multiple. No, that is not first from Mr. Ghosh's personal ground. Professional, I'm sorry. Professional. If I'll kindly keep it. That's our education that we should complete it. Anyone. Not the pass over after I tried to do the same.
Okay. Let Mr. Mitro come. Thereafter, considering his convenience, I can fix a date.
Yes.
In my matter, Your Lordship, item number 39 and 40, my witness.
39, 40. Who is appearing?
My witness is also present. She is coming from Hyderabad. Very old lady.
Just a minute. Let me take up this matter. I've already fixed these matters.
Lordship, in item number 3940, Lordship, I'm appearing for the intervention, Lordship. In the last time the matter appeared, Lordship directed the service was not complete. Lordship, we have served upon the defendants, but so far as the plaintiff is concerned, Lordship, the service could not be done.
Mr. Court, thereafter I shall have. Yes, Mr.
I have a very short reply, my Lord, to give in Lord GA number 9 of 2025.
You are for the plaintiff.
I am for the plaintiff, Your Lord.
Defendant, who is present?
Defendant, I am being led by Mr. Dutt and Mr. Banerjee.
Lord, Mr. Dutt, Lord, has concluded his submission. I'll just give a short reply. Lord, the scope of GA 9 is, Lord, payment of occupation charges. Now, Lord, this occupation charges, Lord, I am not asking for a fresh order. There are two subsisting orders where, Lord, the occupation charges was directed to be paid. Now, Lord, the quantification with regard to occupation charges was done in these two orders. The parties have not preferred any appeal. So, Lord, these orders are binding. Lord, the two orders that are there, I'll just draw your Lordship's attention to. If your Lordship kindly take GA 9.
Yes.
The first order is at page 49.
Yes.
Lord, your Lordships will find that this is the first order that was passed.
Yes.
At page
49.
Yes, it starts at page 49A, which is, Lord, the typed copy. If your Lordships, Lord, kindly come to page 50A.
Yes.
Third paragraph. It is further directed that the defendant shall pay monthly occupation charges of rupees 1 lakh per English calendar month in place and the present rate of occupation charges of 33,000 per month from month of April 2002 to 31st March 2008. It is further directed that the company shall pay arrears occupation charges from the month of April 2002 to 31st March 2003 at the rate of 1 lakh per month. It is further directed that the defendant company lessee shall pay to the plaintiff's lessor monthly rent of rupees 3 lakhs only per English calendar month with effect from 1st April 2008, and there will be increment of 10% of the said monthly rent every 6 years until the expiry of the lease. The extent of increment in occupation charges, rent, as ordered, clause 1, etc., lease deed dated 4th February 83 shall stand modified accordingly. Apart from payment of rates and taxes and other taxes referred to in the deed of lease, the lessee shall also pay all other taxes, including water tax, fees, etc. For the time being, let us concentrate on the occupation charges. Now, my lord, this order, your lordships will take the date, my lord, it was passed on 22nd May 2003. Lord, this was further reiterated, Lord, in the order dated, kindly, my lord, come to the order dated 21st May 2009.
That is page.
Which is at page 55.
Yes.
Lord, this is the operative part of the order. It says by agreed terms filed in GA number such and such is disposed of. The said order passed is for the benefit of the Devottar estate. All parties concerned are to act on a signed copy of the minutes. Now, Lord, the agreed terms of settlement, your lordships will find. No, agreed terms Lord,
anyway, these were argued by you on the last occasion.
Correct,
That
correct.
was
So, Lord,
with reply to any clarification on the reply.
I just want to clarify that, Lord, I am not asking for a fresh order by filing GA9. The order that I am asking for is the continuation of the payment of occupation charges, which was directed to be paid in 2003, followed by an order of 2000.
And that was paid from time to time.
Time to time until they stopped at their own volition.
Yes, by the virtue of this single bench order, thereafter division bench, thereafter the apex court. According to you, you have interpreted the order, which according to the defendant, they have their own interpretation anyway. But the admitted position is earlier they paid.
Lord, not only earlier they paid, they continued to pay until December 2019.
Yes.
There was a letter by which they said COVID intervened, therefore we are unable to pay.
Yes.
And that's how the payment stopped.
Yes.
There is no intervening facts.
Yes.
Lord, starting from the trial court's order, division bench's order, or the Supreme Court's order, none of these orders will not ask them to stop payment of rent,
Yes,
occupation
regarding
charge.
that GA8 and GA9.
Yes.
Whether that GA8 is to be taken up for consideration or GA9. Anyway,
Lord, GA8, your lordship can take GA8 up for consideration. But that does not authorize them to stop payment of occupation charges. Because Lord,
what you have prayed for in GA9.
GA9, I have asked for continuation of the order that has been passed by this court and which has not been appealed from by the parties. It has become final and binding between the parties. Lord, any intervening facts, maybe, Lord, the suit is bad or they want to take a point that suit is not maintainable, whatever it is. But until they succeed and they try and ask for modification of the earlier order to stop them from paying the rent or occupation charges, Lord, that order is in operation. So, Lord, good, bad, indifferent of all the intervening facts, they have never succeeded in getting an order of stay on the payment of occupation charges. Lord, my focus is on that. Lord, whatever happens in GA8, whether your lordships will hear the suit, whether your lordships will frame a preliminary issue, whether your lordships will, Lord, consider preliminary issue and the suit together, these are all outcome of GA8. Lord, that consideration does not authorize them to stop payment of occupation charges. My only consideration is that the order that has been passed by the court
which is not varied or modified.
Continues till date. Lord, a party cannot sit over that order and say, I will not pay for XYZ reasons. Lord, my contention is that your lordship need not even go to any other order. Kindly see the last order.
The order, whether the payment was made directly to you or deposited.
Directly to me.
Directly to you.
Under order of court.
Yes.
And Lord, your lordships will find that, Lord, the Supreme Court kept the issue open. Before the Supreme Court, payment was not an issue. Not an issue. It was only, Lord, whether this demurrer application should be heard or it should be, Lord, on the basis of a preliminary issue that should be framed.
Right.
But, Lord, good, bad, indifferent, these subsequent facts, it does not interfere with the order directing payment of occupation.
This 2003 order.
2003 order followed by the 2009 order. And Lord, the defendant's liability to pay, apart from these two orders, is also circumscribed by a supplementary deed of lease dated 5th August 2010, which is entered into by them, taking into consideration the two orders passed by the court. This is at page 57 to 72 of my GA9, which is registered document. Your Lordships will find from 57 to 62, the order, this supplementary deed incorporates the order, the terms of settlement. Kindly, my lord, come to page 64. The order is quoted clause by clause from the terms of settlement. Page 64, clause 5. Clause 6, clause 7, clause 10. Now, Lord, this document is also not, Lord, anyway affected because there is no challenge to this document. Even if today, Lord, for the sake of argument, even if today my learned friend succeeds in, Lord, having the suit dismissed, his obligation under the sublease, this supplementary lease still remains. So, Lord, for the purpose of considering GA9, Lord, no other factors are at all necessary for your lordships to consider. And Lord, insofar as payment of occupation charges is concerned, if a person is occupying a property, a prime property, he has an obligation to discharge. He says that I am not in possession, I have sublet. Yes, that right you got under the lease. Even under the supplementary deed of lease, you have procured that right, but with a pure contractual commitment that you will go on paying the rent. It is not your sublessee. I have no relationship with the sublessee. So, Lord, look at it from any angle. Suit is good, suit is bad. Till the suit is decided to be bad, the liability to pay occupation charges remains in full force. One just can't sit over the order and say that I will not pay the occupation charges. Now, my lord, one judgment on which, my lord, which was annexed to their affidavit in opposition, the Supreme Court, last Supreme Court judgment, which is at page 127 of the opposition. If I may just place one paragraph of that judgment.
Yes.
Kindly come to page 138. It starts at page 127.
Yes, page 138.
138. Kindly come to paragraph 21. Having considered the submissions made across the bar, we note that the disputed nature of the lease deed, in other words, its continuation or forfeiture on account of non-payment is heavily contested and stemming therefrom. Here, my lord, there is no forfeiture. We have not forfeited the lease. We had forfeited the lease while filing the suit. Lord, after that, the court directed that you go on paying occupation charges. So is in the nature of payment to be made. We also note that the location of demised premises is in the heart of Kolkata, and if the submissions of the petitioners are to be believed, they have been deprived of rent for considerable period of time. Taking a lock, stock and barrel view of the present dispute, the averments and the documents played before us, we may record a prima facie view that the respondent tenant has, for the reasons yet undemonstrated, been delaying the payment of rent and or other dues payable to the petitioner, applicant, landlord. I pause here for a moment. Here, my lord, despite the order of court for payment of occupation charges, they have not paid. Here, my lord, there was no order. Before the Supreme Court, there was no existing order which was being violated. This denial of monetary benefits accruing from the property, when viewed in terms of the unchallenged market report forming part of the record, is undoubtedly substantial, as such subject of just exception. We pass this order for deposit of the amount claimed by the petitioner applicant to ensure complete justice inter se parties. After all, we cannot lose sight of the fact that the very purpose for which a property is rented out is to ensure that the landlord by way of property is able to secure some income. If the income remains static over a long period of time, or in certain cases, as in the present case, yields no income, then such a landlord would be within his right, subject of course to the agreement with their tenant, to be aggrieved by the same. The factors considered supported in our conclusion by the observation and guidelines issued by this court in Muhammad Ahmed versus such and such, we reproduce the ones relevant to the adjudication of the present dispute. And then, Lord, please come to paragraph 22. Since the special petitions are pending adjudication, we make it clear that the discretions made in the above stated interlocutory applications herein are subject to the final outcome of the former accepted. Lord, here, Lord, the court has already exercised as an interlocutory order, directing them to pay occupation charges. Lord, there is no denying the fact that there has been no intervening fact which compels them to stop payment, or the court order has been varied, recalled, modified. So, Lord, in my humble submission, the reference to GA8, the subsequent proceedings in GA8 is only brought in to complicate the entire issue. My case is plain and simple, that if you occupy the property, you have to pay. Otherwise, you surrender. You pay up and you surrender. It's as simple as that. And if you succeed in the suit, still the supplementary deed of lease remains. So therefore, your liability to pay does not disappear. It is the supplementary deed of lease is pursuant to the order passed by this court. So, my lord, I have no further submissions to make in GA9. This is my submission. I have filed my short notes of submissions. And Lord,
and have you filed your compilation of judgment? Any judgment have you relied?
I have relied only this judgment which they have annexed, Lord, to their opposition. This is the only judgment, and I rely on the two orders that our High Court has passed in the suit. These are the two orders.
So anyway, so I can conclude the hearing.
Yes. And Lord, GA8, I again, Lord.
First of all, you have argued with regard to GA9.
GA8, Lord, is a matter which your lordships will have to ultimately decide. GA8 is no longer subsisting. It has been disposed of.
Anyway, according to you, but they have submitted that GA8 ought to have been taken off. Anyway, I shall have to deal with that.
Correct. Lord, my submission with regard to GA8 is very small. My submission with regard to GA8 was, it was...
No, have you dealt with that in your written notes of argument?
Yes, yes.
Justifying GA9?
Yes, yes. GA9, Lord, I'm very clear. This is my submission with regard to GA9.
Why you have, whether you have justified that the GA9 is to be taken up irrespective of the fate of GA8.
Absolutely. And that is how my stand. Whatever I argued today, that is my stand in so far as my written submission is concerned. Yes. So far as GA8 is concerned, it was dismissed by the trial court. The division bench said that you frame it as a preliminary issue. When the matter goes to the Supreme Court says the discretion lies with the learned judge either to hear out the suit or to hear it as a preliminary issue. So, Lord, GA8 does not survive at all. What survives is the order that whether your lordships will hear the suit by itself or your lordships will frame a preliminary issue for the purpose of hearing of the suit. This order, the entire proceedings in GA8, does not interfere at all with the order directing payment of occupation.
That is your contention, that even if the suit goes, that by virtue of that supplementary deed, they cannot avoid the occupational tax. That is your contention.
Yes. And Lord, the court has protected me during the pendency of the suit. That protection order can't be, Lord, taken away at the whims of...
And that was complied without any variation.
Yes, up to December 2019. And there they raised the point that because of COVID, we can't pay you the rent. We are seeking a small time for the purpose of payment. That is the letter written by them. So, Lord, these are my submissions. My submissions is that GA8 is completely different. That has been disposed of, has no connections with GA9. And GA9 is only for continuation of the order that has passed, for which no appeal has been preferred. Parties are never aggrieved with that order. These are my submissions.
Thank you. Yes, record. Yes, from the defendant's side, written notes of arguments have been filed, probably.
Yes, Lordship.
You are sure?
Lordship, I have to take instruction on that.
Okay, then I keep it as to be mentioned for them to file the written notes of
they have
argument.
filed in 3 volumes. 3 volumes are there. It is filed. It is filed.
No, written notes they have filed.
Yes, yes. In 3 volumes they have filed. একটু দেখে নিন এইগুলোই এই মোটা মোটা এইগুলো
এটা একটা
Yes, Lordship, we have filed our written notes of arguments
Okay.
and the compilation also.
Lord, on
The
the
written
judgment,
notes, they have filed their compilation.
yes, on the judgments, Lord, that they have cited, Lord, we have not dealt with those judgments because according to me, Lord, this has no bearing on my application under GA9 because none of these judgments say that you can violate an order of court at your own whims and fancies. So, Lord, I don't intend to go into those issues.
Anyway, you have dealt with the facts of the case according to your own
My
interpretation.
understanding of the matter.
Yes, record an order. Mr. Paul, learned advocate counsel for the plaintiff applicant has concluded his submissions. The defendant has already concluded submission earlier. As the hearing is concluded, the matter be treated as CAV. Let the written notes of arguments filed. You have filed it today.
No, it's already there. You know, Lord.
Let
Much
the matter
obliged.
be treated as CAV.
Much obliged.
Yes, call the witness. Matter.
Lordship, in attempt number 3940, Lordship, I am for the intervener. Lordship, I have filed two applications, GA11 and GA15. Lordship, the service upon the defendant has been done, but the service upon the plaintiff could not be done.
Now, Lordship.
See,
Lordship,
let the service be completed. Thereafter,
no, Lordship, may I submit, Lordship, so every time I have typed to serve upon the plaintiff, it is coming back with the notification unclaimed. Lordship, if the advocate of the plaintiff is there, I can serve it in the court.
Serve it today.
Yes.
My advocate, to the advocate.
Your advocate on record.
Yes.
Yes, today the
Let this be recorded and Lordship, date be fixed for hearing of these two applications after the vacation.
Not filed.
no.
Whether it has been filed in the department.
It has been filed, already filed. It is appearing in GA number 11 and GA 15, Lordship.
15.
Okay, then you can.
GA 15. Is appearing in the list also. GA 15.
Service upon the defendant is complete. Only the plaintiff was left to be served. Plus, you have served to the Lordship. She will kindly record an order and fix a date after the vacation.
Yes, sir.
I am here for the defendant.
Okay. Serve it in course of the day.
Yes, Lordship.
And thereafter, this application will be taken up.
Yes, Lordship.
After the affidavit, after the service is complete. Now today is day fixed for witness action.
Absolutely.
One line may be recorded, Lordship.
And Lordship will record an online order that the service has been done upon the plaintiff.
I shall record that order.
And Lordship will also fix a date after the vacation or will mention this matter after the vacation.
Yes, call the item 39.
39 and 40.
Yes.
All the witnesses.
Yes.
Your Lordship, before examining my witness, I have intention to bring it to your Lordship notice again that in the order dated 13th of August,
आपका पहले हुआ था ना?
the same mistake has been happened. And the name of the advocates for the opposite party has been mistakenly written as Todvanu Saha and Nandini Chatterjee.
Lordship, we are for the interveners. We appeared for the interveners, Lordship, in GA 15 and GA 11.
At that point of time, it was not filed even.
Lordship, I only mentioned that I'm just bringing us leave to file the intervening application.
Not there.
Anyway, that will be corrected.
That order can be corrected, Lordship.
Kindly come to the last order.
That is,
it was to be corrected as per your Lordship's direction. Kindly come to the next page, your Lordship.
Yes.
I have handed over.
You are not the applicant's intervener. You are for the defendant.
I am the defendant.
Yes. So your name will come under the heading for defendant. And with regard to the applicant's intervener, whatever
and their application was not in the existence.
So if it was not there, then how this GA 15 has come? GA 15 of 2025.
Thereafter, it has been filed.
No. Question is on this day. Unless it is there in the list, how it will be recorded in the order? Definitely it was in the list.
It was not, this order was passed, my lord. I have we have handed over to you.
13th August, probably this 13th August, when at the date of the order, this application GA was there. Otherwise, how it will?
On that day, the GA was not there.
No,
Lordship, the GA was affirmed on 7th August.
Filed later than
It was affirmed on 7th August and filed before 13th. On 12th, it was filed.
GA number is not there in the list. How it will be reflected in the order sheet?
That is why the name was not there.
No, name need not be
Name
there.
should not be recorded.
Just GA was there.
Kindly direct them to insert my name.
Yes, that will be there. Definitely that will be
Your
there.
lordship, on that order also, the last dated order, the 28th order,
Your name
dated
has to be
28th of July.
Yes. Your name has to be.
That order was to be corrected by inserting our name. The next page, these two orders should be corrected.
Okay. Yes, it will be corrected at the end of the proceedings.
Yes, my lord, your lordship.
কি হচ্ছে না का नाम
किरण व्यास
किरण व्यास
किरण व्यास
BYAS व्यास
BYAS
ये है ना ওকে দেখালাম উনি দেখে উনি না আগে হয়েছে উনি বললেন আগে ডিপোজিশন আছে তো
Your lordship is already allowed to place the document.
Yes. Upon compliance of all the
After
discovery.
On 13th of August this year, it has been recorded by your lordship that it has been compliance, and then today's date for witness action has been.
Yes, now proceed.
On the last occasion, while the witness action was taken and recorded, your lordship. I put the question that can you produce any document from which you can show your father's signature? The answer was yes.
That was the last question.
This was the question on the last but one. The next question was, have you brought it with you? The answer of the witness was, yes, I have brought the document bearing the signature of my father. Up to this, it was recorded.
Right.
After that, I am taking the question number 26. I am repeating only the 25.
Okay.
Right. I am repeating.
Question number 25 repeated.
কোশ্চেন নম্বর
Question
25
number
রিপিটেড
25
এটা বলা প্রশ্নটা কি ছিল?
Have you brought the document bearing your father's signature today also?
आपने आपने अगले दिन जब गवाही दिए थे आपने बताया था कि आपके पास एक डॉक्यूमेंट्स है जिसमें आपका पिताजी का सिग्नेचर है। आप वो डॉक्यूमेंट आज लाए हैं?
हाँ लाई हूँ।
यस,
Kindly produce the document.
दिखाइए वो डॉक्यूमेंट।
This has already been disclosed.
Please produce the document before the honorable court.
Record it.
Aste. The document is shown here.
Shown the document. Shown the document to the
Please tell my lord about the nature of the document you are producing.
ये डॉक्यूमेंट्स क्या है?
हलफनामा डॉक्यूमेंट।
This is a affidavit.
Please identify the signature of your father on the document.
Encircle করতে বলবো।
Please identify the signature of your father.
आपका पिताजी का जो हस्ताक्षर है ना यहाँ पर वो दिखाइए।
ये है कन्हैयालाल जी सिकवाल।
Yes, there is the
हाँ,
signature of
पिताजी।
my father. The document.
In which language it has been signed?
तो कौन सी भाषा में sign
हिंदी
किया है?
में, हिंदी में।
Please insert the signature.
Encircle से blue pencil करना है। Blue pencil। ये जो सिग्नेचर है ना इसको बोल कीजिए, धीरे धीरे कीजिएगा, ठीक है? Witness encircle the signature with blue pencil. ठीक है?
Deputy mark by.
কত নাম্বার হবে?
না এটা 1 হবে।
ডিপেন্ডেন্টের এটা 1 ফার্স্ট
1
এক্সিবিট 1
এটা না এটা
এক্সিবিট ডকুমেন্টসটা 1 বাই 1 বাই এ 1 বাই এ
1
হ্যাঁ ডকুমেন্টসটা এক্সিবিট 1 আর সইটা এক্সিবিট 1 বাই এ। সিগনেচারটা হচ্ছে 1 বাই এ 1 বাই এ কানাইয়ালাল সিব্বাল এখানে কোথায় গেল? হ্যাঁ পোস্ট টাইটেলে লেখা আছে তো, এটা পেয়ে যাবে, আমি লিখে দিচ্ছি, ঠিক আছে তো?
ঠিক হতে দাও। রেকর্ডিং ঠিক করতে
না 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 এটা রেখে দাও, হয়ে গেল এটা
Exhibit recording.
না আগে হয়নি, এটা এক্সিবিট নাম্বার হলো।
Do you find any legal authorities in presence of whom it was signed?
ये जो डॉक्यूमेंट्स है ना, वहाँ पर कोई लीगल पर्सन जो थे जो जिसके सामने ये साइन हुआ था?
सरकारी, ये सरकारी का ये है पेपर, ये
दिस इज ए गवर्नमेंट पेपर,
गवर्नमेंट पेपर है, सरकारी का स्टाम्प लगा हुआ है,
एंड देयर वाज ए आल्सो सील ऑफ फ्रॉम द गवर्नमेंट ऑफिशियल।
सरकारी का।
दिस इज ए गवर्नमेंट एंड दिस इज ए गवर्नमेंट पेपर बियर द गवर्नमेंट सील। প্রশ্নটা আবার বলো। लीगल अथॉरिटी कोई यहाँ पर है जिसके सामने ये साइन किया गया है?
नहीं, वो डूंगरगढ़ में किया है।
हाँ?
डूंगरगढ़, श्री डूंगरगढ़ में, यहाँ तो कोई नहीं है।
डॉक्यूमेंट्स का जब वहाँ पर साइन हुआ था,
हाँ,
वहाँ पर कोई लीगल
वो स्टाम्प पेपर है ना, वो
स्टैम्प
दिखाया
पेपर है।
स्टाम्प, एक मिनट में,
डॉक्यूमेंट्स
सरकारी स्टाम्प पेपर है ना वो।
You explain the question properly, then you can answer.
ये है ना सरकारी, ये
না ওকে বলতে দাও না, আনসার ঠিক না।
অ্যানসারটা হচ্ছে देयर इज ए सील ऑफ द गवर्नमेंट
अर्थ, हाँ,
ऑफिशियल एट द बॉटम ऑफ द डॉक्यूमेंट।
इनके सामने किए हैं, गवर्नमेंट का ना।
देयर इज आल्सो ए सिग्नेचर एंड देयर इज आल्सो ए सिग्नेचर ऑफ द गवर्नमेंट ऑफिशियल ऑन द डॉक्यूमेंट।
ঠিক আছে, ওকে।
Bottom of the document.
हाँ,
Bottom of the document.
গেছে,
Bottom of
বটমে গেছে, আপে যায়নি।
আপনি তোমার সিগনেচার থাকে। Please encircle the signature and stamp of that official, that government official.
ये जो है ना, इसको गोल
হয়ে
कीजिए,
গেছে, তারপর ওটা কি দাও।
ये गोल के
इसमें ये जो है signature।
No, these government officers' signature she has not seen.
No,
She
no.
knows her father's signature,
Seal.
only the seal,
Seal.
seal and
because she is telling what
Seal
appears
and
in the
signature,
record.
this much. He cannot identify the signature.
No, no,
the
no.
whose, but seal is there.
Yes,
I
at
am
first,
talking about the designation only, to prove the designation as a authentication.
government officers' seal and signature.
Yes,
Okay.
seal and signature.
A by B হবে, 1 by B, 1 by B।
1 by B.
हाँ, witness encircle the seal with the signature of the government official and the same has been marked as exhibit 1 by B।
Please tell my lord, when it was prepared and authenticated.
ये डॉक्यूमेंट जो है ना, ये कब बनाया गया था?
ये 23/7/92 में बनाया गया था, 92 में, श्री डूंगरगढ़ में।
was executed on dated 23
नहीं, 23 92
23/9/92
92 के अंदर
23 जुलाई
श्री डूंगरगढ़ में,
92 at श्री
डूंगरगढ़, राजस्थान।
श्री
डूंगरगढ़,
सराय डूंगरगढ़ হচ্ছে DUNGARGARH राजस्थान।
राजस्थान 92 में बनाया।
Please tell my lord that where from you have procured this document.
ये डॉक्यूमेंट आपको कहाँ से मिला?
मेरे पास था ये।
This document was with me. Is with me. This document is with me. पर ये लोगो दिस डॉक्यूमेंट वाज विथ मी, मेरे पास था।
বুঝতে পড়েছে তো
হয়ে গেছে, আর না তো দিয়ে দিচ্ছি। হয়ে গেছে তো, বলো তো ওটাই তো। হ্যাঁ
Can you tell, my lord, whether you have any information about any other case between sons and daughters of Kanayalal sequel in this honorable High Court other than these two probate cases?
ये जो प्रोबेट केस है ना, इसके अलावा आपके नॉलेज में है, आप क्या जानते हैं कि और कोई मुकदमा है मिस्टर कन्हैयालाल सिकबल का और उनके बेटे के बारे में बीच में?
Kanayalal sequel, son and daughters. Kanayalal sequel, sons and daughters.
हाँ, कन्हैयालाल सिकबल के जो बच्चे हैं ना, उनके
हाँ।
जो पुत्र और पुत्री के उनके बीच में कोई मुकदमा है
हाँ है
इस कोर्ट में? ये जो केस है ना, इसको छोड़ के।
हाँ, चंद्रकला शर्मा ने, मेरी बहन है, वो 2002 के अंदर 371 में वो जुगल किशोर सिकवाल को और हम सब बंटवारा के लिए सूट किया था।
किसने
चंद्रकला
आपका बहन का नाम क्या है?
बहन चंद्रकला ये शर्मा, अहमदाबाद।
There is a suit pending before this honorable court which was filed by my sister Chandrakala Devi.
चंद्रकला शर्मा
Chandrakala Sharma
2002
in the year 2002.
371 कोर्ट ने केस नंबर,
हाँ?
केस
And the
नंबर
case
37।
number is 371.
हाँ, उसने केस किया था जुगल किशोर को सूट के बंटवारा के लिए।
Against the Jugal Kishore, the suit was filed against Jugal Kishore
सिकवाल
for the distribution of the property, for the partition of the property. Jugal Kishore के नाम पर जुगल किशोर सिकवाल for the distribution of the property. Partition of the property.
Number to there.
हाँ 371 खाली बोले जो
Of 2002.
2002 में फाइल किया था वो बेटे बोले जो which was filed in धीरे धीरे बोलिएगा, इतना बड़ा बोल देगा तो मेरा याद में नहीं रहेगा, मैं भूल जाऊंगा। ठीक है, छोटा छोटा करके थोड़ा थोड़ा करके बोलिए।
You have the information of any other cases in respect of the properties of Kanayalal Sikwal?
कन्हैयालाल सिकवल के प्रॉपर्टी के बारे में और कोई केस है जो आप जानते हैं और दूसरे कोर्ट में?
हाँ है, 36 केस है इन भाइयों में आपस में झगड़ा में।
There were 36 cases
भाइयों
were
के
pending between the brothers.
ब्रदर
36 cases were pending between the brothers.
सिस्टर, ब्रदर्स का ज्यादा है, भाइयों भाइयों के,
भाई और बहन के बीच में, ब्रदर एंड सिस्टर।
एक शब्द हो रहा है, डूंगरगढ़ में है, जयपुर में है।
इतना बोलेंगे तो पहुंच जाए।
It will be. The exhibit is to be produced.
Exhibit.
Yes.
The other exhibit.
The documents, yes.
The documents are there. That to be shown to.
Father and sister.
Probate application.
Yes. Judges brings up document. Judges brings up document. Judges brings up document. এটা ফেরত।
দেখা যাবে ঠিক করে নাও না ভাই।
Judges brings up document.
That is the document you are not supposed to get. You will get in your copy. Asking judges copy.
এটা exhibit F টা আমার কিনতে হবে। Exhibit F যেটা আছে দেখি না। List of exhibits টা। এটা কি exhibit? এটা application F
No, start করো।
probate application. The exhibit F be handed to shown to them.
F, shown exhibit F.
Kindly find if your signature is in the document.
देखिए आपका सिग्नेचर इस डॉक्यूमेंट में है क्या? Yes, there is my signature.
You identify your own signature.
आप अपने सिग्नेचर पहचान पाए ना? ये है ना?
हाँ ये है।
Yes, this is my signature on page number 15
This
लीजिए।
is exhibit marked already marked as exhibit F1.
Exhibit F1 है।
F by 1.
This is my signature on page number page 2 of the document, that is exhibit F as signature, and the signature is marked as exhibit F by 1.
Already marked.
Signature is already marked as exhibit F by 1.
Identify it. Can you tell, my lord, about the contents of this document?
आप बता सकते हैं कि ये जो डॉक्यूमेंट्स है इसका क्या लिखा है इसमें, किस बारे में है ये डॉक्यूमेंट?
नहीं।
No, I cannot say.
Can you read it one?
आप ये पढ़ सकते हैं?
नहीं।
No.
And he explained before my lord about the circumstances of signing this document by you.
I am objecting to this question.
No, this is not a leading question.
No,
This is not a leading question.
So if it is some explanation,
My lord, this document has been marked as exhibit.
yes.
And the signature which was there of an affidavit affirmed before the commissioner.
Anyway, now this will go with objection.
Yes.
आप बताइए,
Circumstances only
Okay,
he can make an objection.
आप बताइए,
Yes,
आप
let it
किस
be recorded with
परिस्थिति में
objection.
ये इस डॉक्यूमेंट को साइन किए थे? क्यों किए थे? किस किस लिए किए थे ये डॉक्यूमेंट पर साइन आपने?
वो हमारे भाई हमको बोले कि इसमें साइन करा दो, इसमें साइन कर दो,
My
बिना
brother told
जुगल
me
किशोर,
that put your signature
इसमें
on the
तुमको
document. On the basis of this, I have put my signature on the on the basis of that, I have put my signature on the document.
इसमें छवों का बराबर का हिस्सा सब हिस्सा रहेगा, वो कागज है ये।
And it is, and here it is written that the property would be distributed among the brothers and sisters in 6 equal portion. 6 equal portion, 6 भाग में भाग हो।
Yes, it will go with objection.
Yes. I am explaining these contents of the document, that what it has been written in the document, that it is that you are giving consent in respect of probate of the will.
No, question is, you see, you have asked the explanation whether her signature is there or not. Okay.
Yes.
Under what circumstances it is there. So any clarification is there, you take. No question of giving further explanation. Whether she has understood or whether their signature is there or not, under what circumstances she has signed. That is there, that you have put. Now any other clarification?
That I asked about the content. She has
Yes,
no
yes, she said that she did not
idea.
know.
She cannot read also.
Yes, yes.
And that is why I'm taking the next question. Do you have consent in respect of the grant of probate?
Now you see, this is probably this is also another leading question. Okay. So put it in some other way.
Did you ever given any consent for in respect of grant of probate of your father's will, that Kanhaiyalal Sikwa?
Not again.
Same question.
Again, you see, this is a
Again.
leading question.
Not whether she has any consent
So
or
that
whether
document itself will do.
has given
You see, if it is a leading question, please do not put.
হয় না এইসব প্রশ্নগুলো হয় না কেন করছে
the court may take this for a point or question. Later depose before your lordship.
God divorce. You cannot ask this leading question.
No, question, put some other questions. Other than leading questions, you put any other question.
Did you consent in grant of probate of your
Again the
father?
same question. He's asking the
How
same
it can
question.
be?
No, you can't.
Whether she has consented
No,
or
no,
in the grant of your
See,
father's
this
question,
is
this cannot be said as
No.
this is examination in chief. If it is a leading question, you know what are leading questions. So do not put the question, put some other question in some other way.
The content of the আবার কি তার সঙ্গে
ever you put your signature in any document in respect of grant of probate of your father's will?
आपने
Kanhaiyalal Sikwa,
आपने कोई डॉक्यूमेंट्स पे साइन किए हैं जिससे आपका पिताजी का जो विल है उसका प्रोबेट के लिए?
पिताजी विल बनाए ही नहीं थे, कोई साइन नहीं किए हम।
My father had never executed any will and he had not put his signature, never executed any will. बस इतना लगा। Question time.
Question time.
ঘন্টা সময় যাচ্ছে সব ছেলে মিলে কি যে করছে
Do you know of any document bears your consent? Which bears his consent, her consent?
Your consent.
Your consent. In respect of grant of probate of this will.
Same question, earlier question.
It's a different way.
But he has already said, he has already said the earlier question.
This is only one thing with regard to any document.
Any document, I am talking about any document. In respect of this, the grant of probate of your father's will.
आपने आपका पिताजी का जो विल है ना, इसका प्रोबेट एप्लीकेशन में आप कोई भी डॉक्यूमेंट में इसके कोई भी डॉक्यूमेंट में आपने अपना सम्मति देके कोई साइन किए थे?
नहीं, विल बना ही नहीं था तो सहमति का विल बना ही नहीं था पिता।
Executed any will.
Yes.
What's the name of your husband?
आपका पति का नाम?
वासुदेव व्यास।
वासुदेव व्यास।
वासुदेव व्यास।
VASUDEV
हाँ।
YASH.
ऐसा
Yes,
नहीं।
VYAS.
हाँ।
Yes. वासुदेव
वासुदेव व्यास।
लिखते पारें ना?
अच्छा। ये हस्बैंड है, लिखिए।
Do you know any Asudev Vyas?
आसुदेव व्यास नाम के आप कोई किसी को जानते हैं?
नहीं जानती। अच्छा।
Concluded.
Concluded.
Keep his
So let me fix a date for cross-examination. Yes. Order. Learned advocates for the parties are present. It is EW1. EW1 name?
Kiran Vyas.
Kiran Vyas is present. Kiran.
Kiran
Vyas.
K-I-R-O-N. K-I-R-A-N.
EW1 KIRAN Vyas. VYAS is present in court. The examination in chief of DW1 is complete. On the prayer of learned advocate for the plaintiff, examination of DW1 is fixed. I'm keeping it in the month of November.
After 10th, my
DW1 will be fixed on 11/11/2025.
Actually, he has some occasion which he needs to come. It may be 19.
Okay, I'm keeping it on 17. 17.
17 I have some personal.
18.
18 is also.
Okay, 19/11/2025 at 2 p.m. It is submitted by learned advocate for the defendant, Mr. Thor, that there is some mistake in the order dated 13th August 2000, in the order dated 28 July 2025.
And 13th.
And 13th August 2025. In the order dated 28 July 2025, name of Mr. Thor, Dipankar Thor, is not recorded as the advocate of the defendant. Let the said name be recorded.
And the Rudradhar's name?
Rudradhar name is there and 28 July order.
28 July it is there, but
And
not
the
13th
name
August it is.
of both Dipankar Dhar and Rudradhar does not appear in order dated 13th August 2025. Let the name be recorded let the name of Mr. Dipankar Dhar uh, and Dr. Rudradhar be recorded in the order dated 13th August 2025 and regard to the names of other learned advocates, it remains unaltered.
Lordship in the GA applications, Lordship, let this be recorded that the service has been done on the plaintiff and the defendants has been served.
As GA 15 of 2025
15 and 11, Lordship. To the next matter is GA 15 and GA 11. Two GAs there, Lordship.
Service of GA 15 of 2025 and GA 11 of 2025 upon the plaintiff is complete. Let copy be served upon the learned advocate for the defendant. In the meantime,
Plaintiff is done and service upon the defendant has been done through post. The defendants have received the through post, Lordship. We have the affidavit, we have the track report.
learned advocate for the defendant.
So we have the track report. We shall file the affidavit of service.
Yes. In order, আচ্ছা ওই এই 15 এর আগে করে দেবে না the name of the learned advocate. What is the name of the applicant? Okay, Abhijit. Okay,
Abhijit Sikwal.
Let the name of Mr. Abhijit Sikwal shown as advocate in order dated 28 July 2025 be deleted.
And Lordship will fix a date for the hearing of this application, Lordship.
I'm fixing it for cross-examination. Thereafter, I shall fix it on the said date.
Yes. Wait.
2025.
After the service is come.
Let it be served upon the learned advocate for the defendant. For the defendant. Yes. এটা দেখি ওই next itemটা ঠিক আছে
Okay.
Yes, with regard to the 42.
42.
Yes.
Fixed at 2.
Lordship, my witnesses.
Yes, Mr. Mitra is here.
Lordship, he was.
Mr. Mitra and Mr. Ghosh.
Yes, sir.
So let it be just not today. The witness is present.
The witness is present, Your Lordship.
But I was seeking for an accommodation if it could be kept on that side of the vacation.
Yes.
So I shall be candid. A plan has been given on the last day. Neither Mr. Ghosh nor I can understand head or tail of this. We are seeking assistance to understand this plan. Our cross-examination, the remainder.
Okay, learned advocates for the parties are present on the prayer of learned advocate for the defendant. The matter stands adjourned till 27/10/2025.
Lordship will kindly record that my witness is here and I object
Yes,
to
as
this
the
accommodation.
witness is here and the matter is adjourned, no further adjournment will be granted on the next date.
What an answer.
Obliged.
Grateful.
42. Yes, call the appellate side matters.
So may I be permitted to mention, my lord, item number 41, my lord, there is some urgency in this matter. My lord, the petitioner or appellate side. Okay, sir. Appellate side এটা মেনশন করব
আসতে দিন না সেটা প্রকাশ হচ্ছে
তো ওই দুটো 19 তারিখে পড়া মুশকিল বুঝেছেন 19 তারিখে ডিভিশন বেঞ্চ হবে তাহলে পরে টু বেঞ্চে সোমবারে থাকবে সেপ্টেম্বর তাহলে এটা সই করার দরকার আছে তাহলে 19 তারিখে তো হবে না তাহলে 21 তারিখে হবে
and my lord is a retired employee. My lord, his retirement benefit has been stopped on the pretext. Then since my lord, there has been a charge sheet impending, my lord, he is not getting anything, and my lord, he is starving, my lord. Nothing in the matter, my lord, only for 67 rupees. My lord, charge sheet has been filed.
Which section case?
Lordship?
Case under which section?
My lord, the case under 420, 406, and my lord, under section 120p, my lord, if you collect. And my lord, the allegation is this, that the petitioner was working as a peon. My lord, some documents, my lord, interview letters, my lord, this has been missed. There was a misposting, and that's why, my lord, there was a complaint, and petitioner was nabbed by the BSF authorities. An allegation has
Okay,
been
let
made.
this matter appear. No, let this matter appear as specially fixed on Monday.
Monday or my lord, Friday, tomorrow.
Friday, probably this bench may not sit.
Oh, lordship. Very well, my lord.
Let
At
this-
least of some precedence, my lord,
Yes,
because
let this matter appear as under the heading specially fixed matter on 22/9/2025.
at the top, my lord.
My lord,
Yes, a specially fixed matter means on
my
the
lord, I want to mention today daily list, it is in item number 49. Friday also mentioned, my lord told me to, if it is not come within the list and after Monday, again mention again. The matter is related to the 376 or 4 POXO Act. The framing of charges is fixed on 19/9/2025, tomorrow. And during the time, the accused person preferred an application for discharge for some and want to produce some extra documents beyond the charge sheet documents, which is a clear violation of the apex court judgment. So we want to just agree by this order. Lower court accepted the petition, agreed by the we just file the revisional application.
No, what is 49?
49.
Okay.
It is fixed before the lower court for discharge and the framing of the charges on 19th, tomorrow.
Acha, record an order. Let this matter appear as a specially fixed matter on 22/9/2025. The copy of this application be served upon the learned public prosecutor. Stop. 22/9/2025 as a specially fixed matter. Copy be served upon the learned public prosecutor. Stop. As this matter is sub judice before the court, the petitioner may pray for adjournment before the learned trial court, which may be considered.
My lord, we are not the petitioner before this lower court. We are the
No, you are the
defendant.
petitioner before this court.
Before this court.
So you may pray for time.
But this discharge petitioner, they filed, it is between state and accused matter.
So it's better let the charge be framed. I'm not giving you this opportunity. Let the PP be served and let the matter be heard out. Okay, on Monday.
But the fix is tomorrow for discharge petition. If they consider the discharge petition based on these erroneous documents, it will increase the complexity of the matter.
Question is, you see, I'm granting you that liberty to pray for an adjournment. Even if the discharge petition, okay, I'm granting you that opportunity.
My lord, upload this.
It will be
server
uploaded.
copy.
With your lordship's kind leave, with your lordship's kind leave,
yes,
may I be permitted to mention, your lordship, pursuant to order dated 15th September 2025, your lordship had directed this matter to appear as to be mentioned only for the purpose of filing the written notes of arguments. This is a civil revision application, my lord. Arguments have been extensively concluded before your lordship, and only the written notes of arguments.
Yes, item 3.
No, my lord. No, my lord. Kindly, my lord, takes a look at this order. This has not appeared in the list, my lord. It was supposed to appear today.
Let me see. Yes.
My lord, written notes and my lord, the
So
judgment.
tomorrow has to be mentioned? To be mentioned tomorrow.
It is ready, my lord, whenever.
Yes, yes, tomorrow has to be mentioned.
Deeply obliged.
No.
Our original side of and I am for the petition. My lord, what happened, my lord? Kindly see the my lord, the order which is under challenge is my lord, the 18 January 2025. I am the defendant in the suit. Now, my lord, what happened, my lord? There was, my lord, I am the tenant.
I think probably it was heard earlier, this matter.
Definitely in my lord, in that building. My
So
lord,
why all along you did not take any steps?
my lord.
It's an assigned matter.
Yes.
Anyway.
Yes. Now, my lord, what happened, my lord? The in the tenanted premises, my lord, there was a bathroom for the use of the tenants. The my lord, that was, my lord, demolished by the plaintiff landlord. My lord, that is, my lord, to my lord, evict me in that way. Although the suit is pending. Now, my lord, I filed, my lord, two applications. One, my lord, for commission, for holding commission, and secondly, my lord, for reconstruction of that. My lord, that has been, my lord, rejected by the impugned order. Earlier, my lord, commission, my lord, work was allowed, commission held. Now, my lord, that has been rejected by the impugned order, and consequently, my lord, as of today, my lord, an elderly gentleman, my lord, he has to use, my lord, public bathroom, my lord, every day, my lord, to recite, my lord, for his. Kindly see, my lord, the order once.
Yes.
My lord has gone through the order. This is the situation.
What was your application for?
Yes, kindly, my lord, comes to my application, which is at page, my lord, 26 is the application, my lord.
Yes.
And my lord, two application. One is page 22 and another is page 26.
Yes.
26 was earlier allowed, commission held. 22, my lord, is my application.
26 was earlier allowed.
Earlier allowed
That
report
is for what purpose?
39.7, my lord, to ascertain the position, my lord, of the suit property.
Yes, and 22?
Section 22, my lord, kindly see the prayer, my lord, which is at page 24.
Yes.
May I place the application, my lord?
Yes.
Kindly comes to page 22, my lord, paragraph 3.
Yes.
Kindly see that the tenant several times drawn the attention of the plaintiff who has filed a suit for eviction for taking suitable measure of repairing of the tile shed and replace the bamboo pillars which are very old and damaged condition. Unfortunately, the plaintiff has not willfully taken steps for repairing. That there may be any big incident if the tile shed over the tenanted room are not repaired at the earliest, causing personal damage and the serious inconvenience to the tenant and member of his family. The sanitary privy which was being used by the defendant and the members of his family to excrete since long was put under lock and key, and the landlord when the suit for eviction filed when the suit for eviction forcing the defendant and the members of his family to use municipal drain and privy of the local inhabitants. The defendant and the members of the family although requested landlord to remove the lock, but it did not open the lock and rather threatened the defendant that the members of his family with dire consequences. Now the plaintiff has demolished the privy so that the same cannot be used. The defendant therefore prays either for direct the plaintiff to set up a new privy or to allow the defendant to erect the new privy of in the tenanted premise as the learned court may think fit and proper. Well, this was my prayer.
Yes.
Now, my lord, if your lordship once, my lord, kindly looks at the my lord commissioner's report.
Which page?
My lord, that is
has not been annexed.
annexed. Kindly see, my lord, the
Give a copy of the report to your learned friend.
arekta copy. Well, I'll only one copy, and I'm giving a photocopy and give it to my lord. And if your lordship would kindly comes to me, lord, regarding point number 2, my lord, if your lordship would kind enough to see, my lord, on the bottom of with regarding point number 2, the in its entirety.
Point number 2,
My
with
lord,
regard to the earlier report, earlier application.
that is the only application. Commission, order 39 rule 7.
And this one, this
This
is
is the only order 39 rule 7.
No, you see, commissioner's report was filed, and on the basis of this, it is rejected.
It is rejected.
So which application? Page 22 or
22 was rejected.
page 22 to 24, I think.
Yes, that is the application which has been rejected.
Okay, this is the application. Upon considering the report,
Is the fact that there is no provision of the teacher. Yes.
yes, so this is the report.
My lord, only one thing, my lord, his lordship has seen, my lord, that he says there is no evidence of preview. Now, my lord, kindly, if your lordship would kind enough to come to page 17. Page 17, annexure B. This is the written statement filed by my client.
Yes.
Kindly see, my lord, page 19, para 12.
Para 9, page 12.
Page 19, para 12. Page 19.
Page 19, para 12.
Kindly see, my lord, from the middle, the sentence, my lord, runs, starts with before that. My lord has got it, my lord. Before that, to pave the way for eviction, he by force made disconnection of electricity line from the tenanted premises. Although the defendant did not have any latches whatsoever, the connection was made probably on disconnection was made probably on 5th November 2014. Then till then the defendant has been residing without the supply of electricity. Further, more the common latrine and privy has been demolished, for which the defendant and the members of the family has to use hydrants for easing themselves. This is also stated in my written statement also. And my lord, section 4 of the Premises Tenancy Act, my lord, it is the obligation of the landlord.
So on the basis of the report, your application was rejected. That means the prayer for commission was allowed, and on the basis of the commission, these conditions of the suit premises was given, but the prayer was rejected. No, what was your prayer? That the landlord make the arrangement, or you make your own arrangement?
I'll make my arrangement if the landlord, my lord, statute says, section 4 says it's the obligation of.
No, make the arrangement and to deduct proportionately. That is the provision.
I also do not.
Of the trial judge.
I also, my lord, do not want deduction.
No, what is the ESC?
I also do not want deduction, my lord. I'll make my own arrangement.
Such and such filed by the defendant petition under 35 and such is allowed on contest against the petitioner without cause. It is directed to the plaintiff to cause the replacement of the broken ties and the broken bamboos of the tenancy premises of the defendant, that is the suit property, by the fresh ties and bamboos.
Exactly.
In default, the defendant petitioner can cause the same by fresh ones in place of the broken ties and bamboos without changing the nature and character of the tenanted property. That is the suit property. Giving prior notice to the plaintiff and the statement of the incurred cost to that effect borne by the defendant, that it will be submitted to the court and it will be adjusted by the arrears rent of later on.
Completely misguided, sir. That is regarding the suit property, tile shed I can. What about the my application is for bathroom and privy, that which was broken down. Completely misdirected.
Report held that there is no PV. But they have been asking for the PV, the tenanted suit property, by filing a fresh application under section 35, 36 of the Act.
Question, now you see, so far the commissioner's report is concerned. Commissioner's report has stated the condition of the suit property, condition of the suit property that is there. And so far the point number 2 also. No, regarding there is no existence of sanitary, it is admitted.
That is the
that the commissioner has stated. Okay. So according to you, there is no observation with regard to the sanitary in the impugned order of the learned trial court.
He has permitted me to repair. That is a different aspect altogether.
They have been discussed by the trial court.
Yes, that is that my prayer was, my lord, for sanitary usage. And he has permitted me to, my lord, repair. That I will definitely do. I have already done.
There is no observation with regard to sanitary. And earlier also, it is stated that there is no evidence about the non-existence of sanitary.
Exactly.
Which according to you, there
was broken down
in the written statement.
And this is, my lord, the case regarding by the eviction under section MOP of the Transfer of Property Act, addition on alteration of the building, and other consequential, my lord, the relief they have been paid for.
My lord, would kind enough to me, lord.
No, it is not. No, the case is instituted under the Transfer of Property.
No, 6(4), section 6.
Okay. So under the West Bengal Premises Tenancy
Act. But they have been, my lord, stated in the copy of the plaint. I find kindly come to page 12 of the plaint.
And MOP the one of the ground.
Page 12.
Paragraph 7.
Yes.
The defendant number 1 caused material addition alteration in respect of the premises described in Schedule B herein below. Defendant number 1 has contravened the provision of section 108 of the MOP of the Transfer.
That provision is also there under the Premises Tenancy Act.
Section 6F.
So according to you, that the learned judge did not make any observation with regard to.
And kindly see section 4, it's the obligation of the landlord to provide basic then amenities. Section 4 of the Premises Tenancy Act.
So you are objecting to this petition being allowed.
Being allowed.
And according to you, the learned judge has permitted
Permitted already by
addition and alteration. But there is no observation of this thing sanitary. Yes, record an order. Learned advocate for the petitioner and learned advocate for the opposite parties are present. Hard learned advocates. The hearing is concluded. Let this matter appear for orders on 25/9/2025.
এটা ইন্ট্রিম অর্ডারটা আছে না সেটা হয়ে গেছে হ্যাঁ ঠিক আছে ইন্ট্রিম অর্ডার কাউন্সিলের রিপোর্টটা ওই দিনকে নিয়ে নেওয়া যাচ্ছে রিপোর্ট মেবি
report you if you can give a Xerox copy, it will be necessary.
I'll take it back on that date.
Yes, that you can do.
Passes order.
Great. Yes, on that you can take it back.
Definitely.
Number 2.
Meeting. This is everyday service, my lord. Served. My lord, a case under section 376/417 was initiated against me. Was initiated against me. My lord, it was initiated on April 28, 2023, and subsequent thereto, my lord, we have married each other. I was praying for quashing of the proceedings. In fact, my lord, what we have seen tomorrow is our anniversary.
I'm for opposite party number 2, your lordship.
We could not obtain the case diary. It has still not come, but this is the compromise report, my lord. The victim is now staying with the present petitioner in Bihar. My lord,
She is staying at a matrimonial house. Bihar. Beer council. Beer. Yes. Hey. This is the marriage certificate. Though I have given already, but still in for your order.
I shall pass the final order after vacation. In the meantime, let there be a stay of further proceedings.
My lord, subject to lordship's correction and my sanction by my learned friends.
Yes.
for her evidence, she did not turn up on 2 occasions. Bailable witness warrant had to be issued.
Yes.
Thereafter, she appeared and was granted bail. And the next date is 29th of October.
29th of October. Yes, so far this is your record. So you can you bring the case diary next week? Yes, learned advocates for the parties are present. Learned advocate for the petitioner, learned advocate for the de facto complainant, and learned advocate representing the state are present. Learned advocate for the state submits the written instruction obtained from the officer in charge, Golabori PS station, with regard to the inquiry as to whether the petitioner and the de facto complainant are married. Such report is filed. As the case diary could not be produced, let the case diary be produced on. Yes, when can you produce the case diary?
Monday.
Before vacation or after?
Before vacation.
Monday.
Produced on 22/9/2025. Pending hearing of this application, there shall be stay of further proceedings of GR
GR number is ST number. But my lord, may I say this with deepest respect to your lordship?
Yes.
Since my lord, they have married, and my lord, she doesn't want to proceed with the.
Anyway, I shall pass necessary orders
Yes, my
after
lord.
seeing the case. Is what is the GR case number?
My lord, GR is. আচ্ছা কোথায় 1783 of 2023 এটা my lord কে দাও একটু প্লিজ দিয়ে দিন দাও প্লিজ since the ST number was given my lord we have not given the GR.
Okay, GR case number
middle portion
1783 of 2023, which was pending before learned.
Additional session
No,
judge
no,
5.
earlier.
Oh, earlier.
Learned.
PGM Howrah.
Chief Judicial Magistrate Howrah, and now pending before learned Additional Sessions Judge 5th Court Howrah, being ST number 250 of 2024 for a period of
4 weeks after
for a
vacation.
period of 6 weeks from the date of reopening after vacation.
One indulgence. Can I get a copy of the report from my learned senior friend of the Golabari PS? Can I get a copy of that?
Okay, but just wait for further orders. Okay, thereafter you will get it.
Well,
I'm not directing circulation of this report at now.
As you wish.
Let the report. Let the report be kept in the seal cover.
Well, pray.
Yes.
If she is in a it is possible for the victim to come before your lordship, since we could not record her 161 statement because she is staying somewhere else.
No, you have submitted your charge sheet. Okay, now there is no scope to record that.
No, my lord, only pursuant to your lordship's direction for the verification of this compromise, my lord. We did not have the scope or opportunity. That is why if your lordship is desirous, my lord, she may come. Because generally, my lord, subject to your lordship's correction, in this kind of cases, they file a joint compromise petition along with the quashing petition. Here, they have not done so. This is primarily on the ground of compromise.
Before the learned trial court did the file.
No. Nowhere they have filed. That is why a trial is proceeding in the manner it should.
You see, the officer in charge has submitted this instruction. Definitely upon verification he has submitted.
Because we had called for a report in the manner they could.
Because definitely that is an official statement.
Yes.
So at best, if you want, you can produce the case diary
That we will do.
on Monday.
Well,
thereafter I shall decide. Monday. প্রথম দিকে উপরের দিকে দিয়ে দেবে।
No, 3, 4, 5.
5 minutes I'm paying for not today.
Okay, not today.
6, 7, 8, 9.
My lord, item number 9 and 10 I'm praying for not this week, my lord.
Okay, 9 and 10 not this week.
Definitely.
Eleven,
11, my lord, I am for the petitioner in this matter.
Yes, 11.
11, my lord. My lord, this instant petition is for the expeditious disposal where the petitioner is a victim wife and the relation between the petitioner and the opposite party is husband and wife. My lord, she was subjected to the cruelty and thereafter being aggrieved, the petitioner was when
This
she was.
execution case.
My lord, kindly comes to page number 12. Annexure P2.
Yes.
My lord will kindly appreciate the conduct of the husband here. Today is fixed for ex parte
Ex
hearing.
parte maintenance was awarded.
Ex parte maintenance was awarded. My lord, kindly comes to page number 14, my lord.
Yes, 14.
14, I will read the order portion that the petition for interim maintenance filed by the petitioner B and the same is allowed ex parte. OP directed to pay 4,000 rupees per month in favor of the minor son petitioner of the petitioner within 10 days of every successive month from the date of application, that is 6/9/2021. My lord, this order is dated 16/11/2023. Now, thereafter, the conduct of the petitioner is the petitioner has not paid the arrear amounts in the nutshell. My lord, kindly comes to the page number 23 of my petition.
Yes.
My lord, this mis-execution petition was filed in the year 2024. And even after that,
when is the next date fixed?
Next date, next date before the lower court is that I will have to confirm. My lord, kindly comes to the page number 33. 33, that is the affidavit, and thereafter the certified copy is there.
33.
My respectful submission, your lordship, is that this arrear amount 1,12,000 it is still due.
No, question is that you have to get it from the executing court, okay, by executing the order. So when is the next date fixed? We want to expeditious disposal of what? This execution case?
Mis-execution case.
Okay, so when is the next date fixed? Anyway, so
next date is not only my respectful submission.
Just a minute.
Huh? No.
When it was filed, this miss case? Who's 17 of 2024?
My lord. 24.
Yes. 24/7/2024, 31/8. Five 10/2020. Yes, record an order. Learned advocate for the petitioner is present. It is the contention of the learned. This application is for a prayer is made with a prayer that mis-execution, MC execution number 17 of 2024 arising out of miss case number 267 of 2021 pending before the learned second court of learned judicial magistrate at Chandannagar be directed to be disposed of expeditiously. Stop. Learned advocate for the petitioner submits that although in terms of order passed by the learned magistrate that the opposite party has failed and neglected to pay how much?
1 lakh.
1 lakh?
12,000.
12,000. For which the petitioner wife has filed Miss MC execution number 17 of 2024 and the same is pending till today. Upon considering the facts, this court is of the view that no fruitful purpose will be served by keeping this application pending. Thus, this application is disposed with a request upon the learned judicial magistrate second court at Chandannagar to dispose of MC execution number 17 of 2024 expeditiously and preferably within a period of 4 months from the next date fixed.
My lord, I beseech you, my lord, if this line can be added without granting unnecessary.
4 months fixed without granting unnecessary adjournments.
Deeply obliged.
Now 12.
My lord, I am appearing for the petitioner. Very good. My lord, I am only law point involved in this case. Both the petitioner are the employee of one Madhyam digital news channel. My lord, they publish a news in YouTube. My lord, case has been started under section 196, 299 and 302 BNS. My lord, without
196, 299,
299 and 302 of BNS.
Yes, yes,
My lord,
yes.
in this case, my lord,
section
without
old
section,
sections
my lord, old section 153A and 295. It's a magistrate tribunal, all below the maximum punishment in 5 years. My lord, the sanction is required. My lord, old section is to take cognizance. There is sanction of required from the state government or central government. There is no sanction was prayed for. My lord, cognizance has been taken. My lord, I challenging. My lord,
So
that
196, let me
start. Yes, my lord.
196.
196.
196 BNS.
My lord,
196 BNS.
196 BNS.
196
Yes.
BNS, 299 BNS.
196 and my lord,
299.
299. Sanction is required.
Section
217 BNS.
BNS, yes.
ওইটা খুলে দেন দেখ
Oh, this is only with regard to code.
এটা দিয়ে দাও তো 217 ওইটা দাও
Just
just a minute. Section
217.
217 subsection.
Subsection 1.
217.
Yes. Totally law point in.
Taken my order.
That is 196, 299.
Yes, my lord. Both are here.
Yes.
Yes.
And there is another 302.
302 is similar.
That is 302 for 302 also.
There,
Okay, let us see.
there is no required SOPA 302 is concerned. Well, kindly go through the order passed by the learned magistrate on my lord 18 December 2024. December.
Yes.
Well, kindly go through 18 December 2004 order. Next page is it's a type.
That is.
Yes,
that is the certified copy.
Yes, certified copy. Kindly see the typed copy on the next page, 18/12/2024. Fair for confirmation of AI bail of the accused person, petition, file a petition, return of the seized article. Charge sheet has been submitted.
6/11/2000.
Yes, my lord.
So which order? 6/11.
18 December.
18 December.
Okay. This is in the certified copy.
Yes, certified copy. তুই একটা অর্ডার দেখালি সেটা কোথায় রে কগনিজেন্স নিল কোথায় ডেটটা কবে 18 December.
Accused so and so on AI bill. It looks like this. Looks like
এটা
Yes, where is the order taking cognizance?
it looks like this.
That is okay. That is date of the order 7/2.
18/12.
18/12.
That was Mala's teach actually. Mala kindly.
May I find it out?
Yes. এই ওইটা দাও তো রিভিশনাল কপিটা বার করে দিই, ওটা টিচ হয়ে গেছে, ওটা উপরে এমন কোন
After 4th December's order. After 4th December's order.
after 4th December order.
Yes,
Next.
definitely. Yes, 4th December order is here.
After next page. Thereafter, malo type copy. Thereafter.
Thereafter, there is a type copy.
Yes. Latter portion.
Yes, letter is there.
Yes. Today is IO has filed the report following the modalities of section 193 BNSS, the charge sheet being such and such be made part of the record on perusal of the charge sheet. It has latter portion I have. It has transpired that IO, after investigation, has found prima facie material against the accused person, namely such and such, has indicated them for allegedly committing offense punishable under section 196, 299 and 302 BNS. I have meticulously introspected the charge sheet and the material forwarded with the charge sheet as per 193 BNSS. After such exercise, I find that there is a prima facie material against the accused person and case for taking cognizance has been made out, hence cognizance taken. Magistrate cannot take cognizance so far 217 BNS.
Yes, record an order. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. This application is for quashing of the proceedings of GR case number 1484 of 2024, pending before the Court of Learned Additional Chief Judicial Magistrate, Vidhan Nagar, North 24 Parganas, in connection with Lake Town PS case number 394 of 2024, dated 3/11/2024. Stop. Learned advocate for the petitioner submits that the case has been instituted against the petitioner under section 196 within bracket 2 stroke 299 stroke 302 of Bharatiya Nyaya Sanhita. Stop. Learned advocate further submits that the charge sheet against the petitioner is submitted under the said sections for which sanction was required to be taken under section 217 of Bharatiya Nagarik Suraksha Sanhita 2023. Learned advocate submits that without any sanction, the cognizance is taken by the learned magistrate, and nowhere in the order dated, that is 4/12/2024.
Yes, madam.
4/12/2024. There is any mention.
1812. 18.
412 is the
Okay,
previous
18/12/2024. There is any mention about the sanction being obtained. Stop. Upon perusing the petition and considering the relevant provisions of the statute, this court is of the view that this case should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay. Pending hearing of this application, there shall be stay of further proceedings of GR case number 1484 of 2024, pending before the Court of Learned Additional Chief Judicial Magistrate, Vidhan Nagar, North 24 Parganas, for a period of 4 weeks after vacation.
Grateful.
Number 14.
14 I'm praying for not today only.
Not today.
15, 16, 17, 18.
18.
Yes. 18.
18. My lord, I am for the petitioner. My lord, this is a case, my lord, learned magistrate passed the order in favor of the minor aged about 4 years, rupees 9,000. My lord,
Which page?
okay, my lord, kindly come to page 43. Page 43, my lord, impugn order. $9,000 per month. Only for minor because marriage not admitted. In respect of wife, my lord, so-called wife, that was rejected.
When was this order passed? 21/6.
My lord, 21/6/2025. Page 43, my lord.
Yes.
Now the fourth paragraph, it is pertinent to mention this is initial stage of the case. Facts in issue raised by the party
Oh,
can
this
only
is
be
this is not. Is it
interim maintenance.
interim?
Interim. Now the court comes into question of quantum of maintenance. Maintenance proceeding is not to punish a person for his past neglect, but to prevent vagrancy leading to the commission of crime, starvation, such and such. Thereafter, my lord, considering the all initial factor of the case, amount of 9,000 for the minor. Minor who is aged about 4 years. The my lord mother, it is evident from the my lord the documents, unimpeachable documents, that page 31 onwards, the mother has at least 4, my lord, flats at Central Calcutta.
Mother's, you see,
My
mother's
lord, not only
maintenance
that,
is rejected. It is the child's
okay,
maintenance.
my lord, rejected.
No, you see, child above the 4 years.
Well, above 4 years.
Okay, he is
So
to be admitted to school
my
after
lord,
4 years.
per day 300, my lord. My lord, according to London magistrate, my lord, per day, my lord, 300. But see, I am paying for, my lord.
Any area? Oh, this is ad interim.
Ad interim. Subject to payment of, my lord, some reduce some amount, my lord. Kindly.
No, is there any direction to pay the area amount?
No, my lord. Nothing, my lord. Considering last page, page 43, considering all initial factor of the case, income of the party, and after perusing the material on record.
No, what is the income according
9,000.
to? Oh, it is not expert. It was hard.
Hard.
How much? No. How much is the income of the father?
33,000.
33,000.
Mine.
So you see, so far wife is concerned, it is rejected. 33,000, 9,000.
Rejected because he's not at all a wife.
33,000 from 9,000, it is not even, you see, half.
My lord, but
Not
my
even half.
family, everything with my lord, this is, I am a man. She also a married woman, my lord. और येटा कोई Subodip Banerjee.
Yes, record and order.
Lordship, kindly reduce some amount, my lord, and
Learned
copy
advocate for
sharp
the petitioner
upon
is
the opposite
present.
party, my lord.
Hard learned
I
advocate
will
for
pay,
the
my lord.
petitioner. This application is directed against the order passed by learned judicial magistrate, Second Court, Shialda, South 24 Parganas, in M case number 164 of 2024, directing the petitioner to pay rupees 9,000 as interim maintenance. Learned advocate for the petitioner submits that the interim maintenance with regard to the wife was rejected by reasoned order And so far the payment of maintenance of this minor child is concerned, it is high considering the income of the petitioner. Upon considering the facts of the case and upon hearing the learned advocate, this application is admitted. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of the order dated 21/6/2025 passed by learned judicial magistrate, Second Court at Shialda, South 24 Parganas, in case number 164 of 2024 for a period of 4 weeks after vacation, on condition that the petitioner shall go on paying rupees 7,500 for the minor child within the 8th day of every succeeding month. Stop. In the event there is failure to pay the interim maintenance of rupees 7,500, the interim order will stand vacated, and the parties will be at liberty to take steps in accordance with law.
My lord, one thing I'm wrongly submitted.
Yes.
My lord, interim maintenance in respect of wife not rejected. She did not pay. Only she pay for only minor daughter. Not, my lord, page 13.
ওইটা, but with regard to the interim maintenance of the minor, wife এর যেটা আছে ওটা কি কেটে দেবেন, ঠিক?
Only minor daughter.
So only the minor child.
Minor child.
Okay.
Get to your lord.
ওই minor যে ওয়াইফের জন্য is rejected ওই জায়গাটা কেটে দেবেন।
Get pull your lord.
Number 19. Item number 17, my lord. I'm just running from court number 28, my lord.
Just wait.
My lord, my lord.
19. And 19, my lord, expeditious disposal of a complaint case. In a proceeding, my lord, case of 2019, plea recorded in 2020.
You are what? Complainant?
Complainant, my lord. Case of 2019, plea recorded in 2022, my lord, page 13, my lord. Till now, evidence has not been prosecuted. But this is the last order, my lord, I subsequently obtained. Date was fixed on 22nd of August 2024 for evidence. Evidence has not been.
19th of August 2024.
Subsequently I obtained, my lord. This is a certified copy, my lord. I am having.
So, what is this order?
Order, my lord, 22nd of August 2025.
Okay, charge is framed.
Plea recorded, my lord. Page 13, my lord.
Page 20.
Page 13, my lord. 13.
Page 13.
My lord, kindly see.
Yes.
According to substance of accusation of the fact of commission of offence under section so and so read over and explained to the accused and Bengali, and which they pleaded not guilty and claimed to be tried by saying am need to in 2022. And I having the certified copy, the latest order, my lord, 22nd of August 2025 was date fixed for evidence, but evidence not recorded, my lord.
When it was fixed?
22nd of August 2025, not recorded. Next date in, my lord, something in October, my lord.
Yes, record an order. Great. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. This application is for an order directing expeditious disposal of CR case number 208 of 2019 under section 138 of the Negotiable Instrument Act, now pending before the learned judicial magistrate, Second Court, Chandanagar, Hubli. Learned advocate for the petitioner draws attention to the order sheets of the learned magistrate. Learned advocate submits that although the case is pending from 2019 and the charge has been framed, but the trial has not yet commenced. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that no fruitful purpose will be served by keeping this application pending and directing service of notice upon the opposite party. Thus, this application stands disposed with a request upon the learned Judicial Magistrate Second Court Chandanagar, Hooghly, to dispose of CR case number 208 of 2019 within a period of 3 months from the next date fixed.
Great.
But not 20.
Well, at 20, my lord, I am for the petitioner.
Yes.
Prevention of Corruption Act. yes. Prevention of Corruption Act. Well, lord, this is under the Prevention of Corruption Act. My lord, this is the second round before this honorable court. My lord, the petitioners before your lordships, my lord, they are husband and wife. My lord, the petitioner number 1, my lord, is a lady, my lord, 62 years old. My lord, she is a businessman, my lord, in her own right, my lord. Petitioner number 2, my lord, is, my lord, the superannuated, my lord, railways employee, who is now 67 years old. Now, my lord, the case that is alleged against the petitioners is that of, my lord, disproportionate assets. Now, my lord, initially, my lord, we had, my lord, filed a computation before this honorable court. My lord, in fact, my lord, the CBI, my lord, in the charge sheet, my lord, acknowledged the fact that the petitioner number 1, wife, she had an independent income, and that, my lord, she was doing business from, my lord, from the late 80s, my lord, from much prior to, my lord, the alleged check period. Now, my lord, despite acknowledging all that in the charge sheet, my lord, the CBI chose, my lord, to file charge sheet against the 2 petitioners. Now, my lord, these 2 petitioners, my lord, they approached this honorable court. My lord, kindly have, my lord, page 113, 113 of my application. Justice Tirthankar Ghosh's order, my lord. 113, my lord, in the first volume, my lord. There are 3 volumes, my lord, perhaps. Kindly see the first volume, page 113.
Yes.
My lord has got it, my lord. My lord, firstly, my lord, my submissions are recorded. Then, my lord, kindly see the second page, page 114. My lord, the third paragraph, the sentence starting with the check period. My lord has got the check period, as has been stated by Mr. Chatterjee, is from 2004 to 2011. Petitioner number 2 is carrying on the business. And the petitioner number 2 is the wife. Well, lord, there's just a reversal. In this revision, petitioner number 2 is petitioner number 1. Petitioner number 2 is carrying on business in the year since 1989. Now, my lord, the direction of the High Court. The learned trial court would assess after 9 years whether it would be prudent to pursue with the complicity of the petitioner number 2 when it is accepted by the investigating agency that there was an existing business. So far as the amount is concerned, which has been quantified to be disproportionate, the learned trial court would take into account, relying upon the judgment of Honorable Supreme Court reported in Krishnanand Agnihotri so and so, and thereafter arrive at its findings as to whether further continuance of the trial of the case would be called for in the background of the facts and circumstances of the present case. Next page, my lord. Next date has been fixed on so and so, and the learned special court, seeing the agony being faced by the petitioners for the last 9 years, would fix at least one date in a fortnight and dispose of such application within 45 days from the date of filing. So, my lord, the Honorable High Court, my lord, took a judicial note of the fact that, my lord, firstly, there is no point pursuing with the petitioner, the lady, so far as her complicity is concerned, after 9 years, where admittedly, as per the, my lord, CBI's own charge sheet, she has been having an independent business, independent source of income, and independent, my lord, ITRs much prior to the check period. From the late 1980s, my lord, she is filing, my lord, her returns. Now, my lord, based on this, my lord, the High Court granted us liberty to take out an application before the trial court.
That is what, for discharge?
For discharge. Now, my lord, we take out that application. My lord, that application, my lord, will find, my lord, starts at page, my lord, 117. Kindly have, my lord, page 117, my lord, in the same volume.
Yes.
We once again, my lord, whatever we had said before the High Court, we reiterate all those explanations, particularly, my lord, in paragraphs 27 to 33. My lord first has got page 117.
Yes.
My lord, this is our application pursuant to the High Court's liberty that we have, my lord, also pleaded. Now, my lord, kindly have, my lord, page 137, the continuation of that, my lord, petition. Kindly have 137 once, my lord. From paragraph 27, my lord has got, my lord,
Yes.
that is internal page 21 of our petition.
Yes.
Para 27, my lord, from 27 to 33, once again, my lord, we give the explanations with regard to, my lord, the fact that there is no disproportionate assets. And that, my lord, explanation is, my lord, from paragraph 27 to paragraph 33 of this application. I mean, my lord, the application that was filed before the learned trial judge. My lord has kindly seen that, my lord.
27 to 33.
33. Up to running page 158. We give every detail, every factor, which are already, my lord, a part of the, my lord, chart sheet. We again reiterate that because the High Court asked us to do it.
These are the part of the chart sheet.
Chart sheet.
Whatever
Yes.
materials was collected.
Yes. Now, my lord, the most interesting part.
You know,
My lord, your lordship knows.
Regarding your income and
Yes.
expenditure.
An explanation.
And
Now,
your returns.
And my returns. Now, my lord, the most important part comes now. My lord, your lordship knows in every, my lord, petition which is filed, the CBI files a counter. In this petition, when we filed, they filed a counter. That counter, my lord, or that written objection is at page 601, the last volume. Page 601. My lord, initially I have shown, my lord, paragraphs 27 to 33 of my application, where, my lord, I have given the explanation.
Yes.
Kindly see in their counter how they are dealing with that. My lord, their counter starts at 601, relevant part 604. Paragraph 5. This is how they are dealing with my explanations. Kindly, my lord,
604. Yes.
Kindly see, my lord, the third line from the top, that as far as the averments made in para 27 to 36 of the petition is concerned, these are contentions of the petitioners, and the learned court may find merits, if any, in the contention during trial, hence no comments. So, my lord, this is, my lord, for them I understand it is difficult to say yes. But then, my lord, they kindly see the drafting. This is what.
Now, that is the question of law, whether at the time of this discharge petition, 227 discharge, whether the materials, the documents of the defense can be.
They are not defense. They're all part of the investigation. My lord, kindly visualize this. My discharge application and the explanations given were pursuant to the High Court's direction. I applied for quashing before the High Court. The High Court, kindly come back to the order of the Honorable High Court once, my lord. The order of the Honorable High Court, my lord, is at page, my lord, 113.
Yes.
Kindly see, my lord, page 113 in the first volume.
Yes.
My lord, kindly see the first page once, my lord. Second paragraph. Then your lordship will get the backdrop. My submissions, my lord. Advocate submits in this case accounts which have been placed by the investigating agency are full of inconsistencies, and they do not tally with the income tax return of the petitioner number 1 as well as that of petitioner number 2, who happens to be the wife of the petitioner number 1, who is a public servant. According to the learned advocate, CBI has accepted the proposition of business of the wife, the petitioner number 2, being carried out since 1989. However, investigating agency submitted charge sheet against petitioner number 2. The investigation in the case commenced in the year 2014, and it is almost 9 years since the initiation until date. The lady is being drawn to the court of law without any fault of her, as is submitted by the advocate for the petitioner. Be that as it may, next date has been fixed on 17 November for hearing of the application of closure of further investigation. Now, my lord, is the relevant part. The check period, as has been stated by Mr. Chatterjee, is from 2004 to 11. The petitioner number 2 is carrying on business since 1989. The trial court would assess, my lord, kindly see, this is the direction of the High Court. The learned trial court would assess after 9 years whether it would be prudent to pursue with the complicity of the petitioner number 2 when it is accepted by the investigating agency that there was an existing business. So far as the amount is concerned, which has been quantified to be disproportionate, trial court would take into account relying upon the judgment of Krishnanand Ognihotri and thereafter arrive at its findings as to whether further continuance of trial of the case would be called for in the background or not. It is, my lord, on the basis of this that we took out that application. We again, my lord, gave the explanations from paragraphs 27 to 36. And, my lord, in the counter, the CBI says there may be merits in that. That is their, my lord, stance. My lord, I understand, my lord, they cannot say that, yes, the proceedings should be dropped. They cannot perhaps say that. But, my lord, at this stage, I was, what I was praying before your lordship
Let
is...
us now see the order.
Yes. Now kindly seize the order, my lord. Kindly see, my lord, in the third volume, the last, my lord, part. Huh? Yeah. After, my lord, page 605, my lord. After page 605. 604 I have shown to your lordship.
Yes.
That how they have dealt with my explanations.
605, let us consider what is the observation.
Yes. My lord, observations are, my lord, palpably illegal to the extent, my lord, the learned judge, he has only, my lord, said that everything is a question of trial, so I will not interfere. And very, my lord, uncharitably, my lord, he has said that, oh, how the petitioner has become a billionaire. My lord, billionaire means something else. Relevant part of it. Page 98, no? The learned judge, my lord, in my respectful submission, my lord, gives no respect, my lord, to the dicta of the Honorable High Court, on the basis of which, my lord, the petition was filed. He doesn't give, my lord, any credence to the pleadings that were before him, and all those pleadings were filed pursuant to the Honorable High Court's order. The High Court would have dismissed my application, my lord, if there was no merits. The High Court, the Honorable High Court wanted, my lord, the learned judge to go through the documents once again. And he only, my lord, makes, my lord, very broad observations. Whereas he was supposed to go into very deep into the matter. Particularly when the CBI itself is taking a stance at page 604. My lord, I have very seldom seen, my lord, CBI taking such a stance. In fact,
Which page of the CBI that is?
604. 604. They took a very soft stance. They cannot say, please drop the case. But they say the learned court may find merits. They do not say that my explanation in para 27 to 36 is baseless, false, frivolous. They don't say that. As a agency, my lord, what more they can say, my lord? Lord, at this stage, I was praying that I will serve notice on the CBI, my lord. Kindly grant me a short stay in the meantime, my lord. Because your lordship has seen the previous order of the High Court also, my lord. The High Court was also worried that with after 9 years, and now it is more, my lord. After now 11 years, whether this elderly couple, my lord, they should be proceeded against. And where there is nothing against them, my lord, they have explained everything.
Yes, record an order. This application is filed seeking quashing of proceedings being special case number 4 of 2020 pending before the learned special judge PBI court number 1 Alipur South 24 Parganas arising out of PBI stroke SPE stroke ACB stroke Kolkata case number R capital C capital 0 capital 0 then 1 0 2 0 1 4 capital A 0 0 1 4 আরেকবার বলছি capital R capital C 0 1 0 2 0 1 4 capital A 0 0 1 4 dated 31/5/2024. Learned advocate for the petitioner submitted that the learned judge has passed the order rejecting the petitioner's prayer for discharge without considering the order passed by this court in CRR 2929 of 2023 dated 14/8/2023. Stop. Learned advocate draws attention to the order dated 14/8/2023, where it appears that the learned coordinate bench was pleased to pass the following order. আচ্ছা সেট আউট হ্যাঁ পেজ 2 এখান থেকে দি ইনভেস্টিগেশন থেকে আরম্ভ করে এখান থেকে এটা ফোল্ড করে দিচ্ছি learned advocate further submits that in terms of the direction of this court, the petitioner filed a detailed application giving all necessary particulars, but the same, although not being specifically denied by the prosecution investigating authority,
lordships,
but the same were not taken into consideration by the learned trial court. Learned advocate has referred to the averments made in paragraph 27 to 36 of the discharge petition, giving necessary particulars of the source of income and the documents with regard to the same, where the prosecution CBI has stated that this may have some merits and may be considered during the trial. Stop. It is also submitted by the learned advocate that these documents and detailed contentions made in the several paragraphs of the discharge petition were not dealt with specifically by the prosecution in their objection. Thus, this ought to have been taken into consideration by the learned trial court. Learned advocate also draws attention to the order passed by the learned trial court, where the learned trial court observed that the grounds mentioned in the petition seems to be a copy paste of any application made before the Honorable High Court, and there is clear prayer for setting aside or quashing the order, prayer for setting aside or quashing the order by exercise of section 482 of CRPC in ground 5 and ground 9 of the petition. Stop. It is submitted that there is no specific observation of the particulars given by the petitioners in the discharge petition, and which is not specifically denied by the prosecution. Upon perusing the earlier order passed by a learned coordinate bench, the discharge petition filed by the petitioner, and the order passed by the learned trial court, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite party within 1 week. An affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings of special case number 4 of 2020 pending before the learned special judge, CBI court number 1, Alipur, South 24 Parganas, arising out of CBI stroke SPE stroke ACB stroke Kolkata case number R capital C 0102014A 0014 dated 31/5/2014 for a period of 3 weeks after vacation.
I'm deep blue.
Yes.
Compelling situation I'm
Yes.
The original side matter 2 o'clock, which was fixed.
Reminder
Because
click
the court has made the arguments. I was being led by come back to lordship.
No, because you see, after reply there cannot be any reply. Okay.
To inform your lordship.
Your junior was there.
Yes, yes.
Yes. Now the question is, it is not the none appeared because it was for Mr. Court to give the reply. Thereafter conclude because there is no scope. There is no scope after reply to give any reply.
Reply after reply.
Yes. Then.
It's about what I was expecting.
Yes.
I told to your lordship.
Yes.
Last week, everyone has sat at Mr. Duck's chamber for settlement. Unfortunately, I was in court number 36. I'm very sorry. I apologize. I was on my legs.
Yes.
Mr. Duck was also on his legs.
Anyway, so I can do no, at best I can do one thing. You mentioned tomorrow upon notice upon
I'm before your lordship by informing the other side.
no question is if you mentioned tomorrow in the morning. Yes.
Kindly keep it under the heading mentioned tomorrow, as it is going to be taken up after your lordship finishes the chamber matters. Both of us will be there. All of us will be there. I want my senior in the matter has become furious on.
No. Question is, you see, because you see, I took it up because after reply there is no scope. And just because you see, whatever you have to deal with, you deal with in your written notes.
We enjoyed cup of tea and biscuits, and now this thing has happened. Matter is
No, whatever it is, you see.
Kindly keep it under the heading to be mentioned. I'll inform Mr. Kaur personally, and Mr. Dutt,
It's
anger
better.
over me would come down.
No. Question is, it's better. You tell your senior that I have directed to mention it at 2 p.m. tomorrow, and definitely it will appear as to be mentioned.
I'll mention at 2 p.m. upon notice.
Yes.
I'm sorry for.
Or after the chamber matter, whichever is earlier.
I'm sorry for the untimely mention.
Yes.
Deep blue.
Item number 17, can you fix it day after tomorrow?
Yes. Retype. Yes.
Item number 17,
Item 17. You take your chance tomorrow. If it
day after tomorrow, I have
day after tomorrow, probably this bench may not sit. Okay.
Then
So let it be tomorrow. If you are if it is not taken up next week, you mention.
I'm grateful.
Thank you so much.